Subcommittee on Temporary Governance Officer. I'm going to start by reading some points from the hearing protocol. Only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communication via the chair. Please ensure that your mics are muted when you are not speaking. When speaking, please be succinct and do not exceed the allocated time frames highlighted at the start of the hearing and contained within the agenda pack. If you're referring to a specific page or picture in a report, refer to the page number. If you are having technical difficulties, please use the chat function in Google Meet to alert the meeting. Please do not use the chat function for putting formal questions to the subcommittee. Any persistent disruptive behaviour will result in removal from the meeting. At the end, applicants and all other parties will be asked to leave the proceedings. Once all applications have been considered, any remaining parties will be asked to log out of the meeting. Please do so promptly so that councillors will have the opportunity to deliberate and make a decision on each application. Please could I ask the subcommittee to appoint the chair?
Could I nominate Councillor Peter Snell?
Unseconded. Thank you.
Thank you, fellow councillors. Can I just apologise to people that the procedure that's gone into the agenda is the wrong one, basically. So I'm going to go through the correct procedure, which I have in front of me on timescale. So, appointment of chair and introduction, 5 minutes. We need to know who everybody is. Then it becomes the licensing officer introduces the case to the applicant, which in this case is the police, make their application for the review. Other responsible authorities can come in at this stage, which is in this case environmental protection. We also have an other person coming in, and then we will have a discussion. Now, at that stage, under these remote meetings, we have to retire and consider our decisions separately. In the past, we used to go out of the council chamber and come back in, but at that stage, people will leave us. First of all, Sarah, I see you've got your hand up there. Is there a question you want to know about how we're going to run today's procedure?
Yes, Chair, thank you. And at your convenience, but the 2 points are the time that's allowed to make representations and also notification to Newit's Guildies, who I do not represent, but is one of the licensees. And so as a matter of courtesy, I'm raising it to the committee, because if there's any possibility of a revocation of a license today that's held in the name of another person as well, that is something that you may wish to consider as a point of law as to whether she's been properly notified. As I say, I don't represent her, but we have proceeded, we've started, and so it's right to raise that now. Also, I've spoken to my learned friend, Mr. Lardenberg, for the police in relation to the 5-minute rule, and we'd like to address you on that at the right time, please.
Amanda, can you advise us on that, please?
Thank you, Chair. I understand that emails were sent through prior to the hearing. It is in accordance with the procedure, the hearing procedure, that we only allocate 5 minutes to each party. It is at the chair's discretion whether or not they grant additional time, but I understand that they're only prepared to give 5 minutes. And as the meeting progresses, you will have further opportunities to make representations, for example, in the discussion phase.
I think we would be prepared, though. We understand this barrister is here today. I think we'd be prepared to give you 5 minutes each, but that we consider very more than generous. We're certainly not going to let you go on for 20 minutes, because basically, if we need more information, we'll come back to you in the discussion phase. That's where we want to interrogate the defence that you're going to be putting forward today. Okay, it does say, in fact, requested to depart from the hearing procedure. So they all seem to be coming from you, Sarah, but what's your other concern?
I haven't actually addressed you on the need for longer than 5 minutes. So I was asking when the right time was to do that.
Well, I guess you do that now as well. Fire away.
Thank you. I'm making a formal application to the committee for a longer period than 5 minutes. We have got a summary review, which may result in the revocation of somebody's business and the loss of employment to up to 35 people. I'm facing 2 responsible authorities, the police and the environmental health, who've made substantial submissions, to which I've not yet had an opportunity to address the committee on points of fact and law that might change your mind. Very, very few committees in the country now apply any time frame of a rigid sort at all. Nobody else, to my knowledge, does 5 minutes. The Institute of Licensing has been training against it for the last 10 years on the basis that it is not Article 6 compliant. It doesn't comply with the requirements of a hearing and human rights when somebody's about to lose their business, and I am unable to address you effectively in such a short space of time.
People that. Mr. Leidenberg, you, I think, are also raising a point of procedure.
Yes, so I agree entirely with what Ms. Clover says, and also on a pragmatic basis, a bit more time spent in our submissions is likely to save time later on. You'll be aware that when the summary review was applied for, there was a standard review pending. That involved an awful lot of evidence that parties have agreed should be considered in this hearing to prevent your committee from having to have an identical hearing in a few weeks' time. And just so that parties can understand a slightly complex situation where there are in effect 2 reviews of 3 individual licenses, 5 minutes is simply impossible to give a fair overview of the situation, and the few more minutes granted to me at the beginning is, I think, likely to save confusion further down the line. So I encourage a little more leniency just on a basis of pragmatism.
We had a discussion about before the start of the meeting. I'm probably not going to be completely rigid. I'll be honest, I have had to sit through very long presentations that I've regarded as completely irrelevant to the facts before us, and I do get impatient with them. So I hear what you're saying about there being a lot of evidence in this case. Can I promise a degree of leniency, but if necessary, we're going to cut it back to 5 minutes, because we just don't want to be lectured out for 20 minutes on things that we're experienced people on this committee. You know, we should know when we've heard enough. Do you want to come in here, Amanda, and just advise us on our legal situation? Sorry, I can see Amanda's on the phone. Did you hear that, Amanda? I was asking if you wanted to come back and comment on those points that have just been made.
Sorry, no, can you make those points again to me? Sorry, thank you.
Well, the point is we're being told that, in fact, our normal limits violate people's human rights. I said that normally, you know, if somebody chose to represent themselves and had a legal advisor, they'd get 2.5 minutes each, because we're confident that we can interrogate the matters before us in the discussion. What's also being argued here is the complexity of the review that was planned anyway before this incident. It requires a whole load of extra evidence that is now before us today, and that means that we should allow more than the time we are allowing. Can we just have your advice on that?
It is at the chair's discretion to grant additional time if they wish to. My understanding is that each representative has 5 minutes each, not 2.5 minutes each. So
that's what we agreed for today. Yes.
Yes, and that I think that given that there are 3 separate decisions that will be made, that does warrant some additional time if you're minded to grant it. But it is at your discretion whether or not you feel that's appropriate. The other thing I suppose maybe you could say is, do you feel that in the paperwork that's been provided, has that provided you with sufficient information so far, or are the representatives going to be adding more information on top of what they've already submitted? I think that's the point, really, because we don't want them repeating again what they've already submitted as a submission or a representation of the case. So I suppose maybe if you wanted to clarify that.
Okay, so Helen and Guy, can you tell us, are you going to submit
So I hope to make your lives a great deal easier by identifying exactly which parts of the evidence will assist you. I'm conscious there are many hundreds of pages of evidence. You won't want to read, for example, many hundred pages of CRIS reports without a little bit of explanation. And I'm confident that in 10 or 12 minutes, I can give a very brief digest that will pinpoint the evidence that will assist you in making what's not a totally straightforward decision. So I certainly don't want to waste your time or bang on or repeat myself. I simply want to use a few additional minutes, in fact, which we've already exhausted, in making your lives easier. So that's on the Metropolitan Police aspect. That is our only intention. And if I bang on, you can blow a whistle.
I think that's fair.
We're talking about, we've had a specific explanation there of why Mr. Ladden wants extra time. Why are you asking for more than 5 minutes? What value will it add to the quality of the evidence that we hear?
It's almost impossible to explain that without undertaking the representation, sir. I'd have to tell you what I'm going to tell you so that you know whether what I'm going to tell you is going to tell you something additional to what I would otherwise have told you.
Well, okay, that's not particularly convincing at the moment. Look, I'll aim for 5 minutes. If you're going over and you can produce some sort of logical reason for why we should listen, like promising that we will more clearly understand the evidence before us, then I may well be tolerant on that 5 minutes. But at the moment, I think I'm going to be tolerant of Mr. Laddenberg. Sorry, I can't see your name fully here. You know, we'll wait and see when we come to yourself. Right? Can we start?
Sure. Another matter. I noticed PC Giles has been attempting to join the meeting several times and being refused access. Is she with us?
Hello, I am here on my phone. Unfortunately, my laptop's not letting me in. So when it comes to later on, and I may need to show CCTV, that we may need to have some discussion around that. But I am here. Yes, thank you.
Okay, yes, well spotted. It is essential people involved in this are here for the whole hearing. Right, so with the procedure's been challenged at the start, that's held us up a bit, but we now, I think, need to go round making introduction. I am chairing this meeting. I represent Dalston Ward. My other councillors who are here can introduce themselves now. Councillor Bell.
I'm Councillor Brian Bell from Brunswood.
And Councillor Smith.
Yeah, Councillor Smith from Stoke Newington Ward. Thank you.
Okay, and please, officers from the council, if I miss anyone, jump in and tell me. But Peter Gray is here as our administrative support. Amanda is, there's probably a better word for that, Amanda is here from our legal department to make sure we do follow the rules. We've got 2 people from the licensing department. We've got Sue Bangini, who is the person who's put the paperwork together today for today's meeting, and somewhere or other we had David, who is the manager of the licensing section. Now, is there anybody else here from the council? So I'm looking at the side now. Oh yes, we also have George Wakarash, who is here from Environmental Protection. Have I missed any? And we've got Mario Karaman, who is simply our IT person, a very important person, to make sure the system works all the way through. Are there any other council officers here that I've missed? No, I'm going to take silence for meaning that I've covered everybody. Right, yeah. So, through people in the way that they don't give evidence to us today. Actually, I think I've got to say something on procedure. We've had quite a complicated pre-meeting today because we had various items to discuss. One of them is the fact that there's been a request that this become an exempt meeting, that basically we exclude the public and the press when we start to consider this application for a review. We've decided, because we have another person here today, we have somebody who wants to produce evidence on behalf of local residents. And in considering the request, we've taken the view that that person should be allowed to stay through the meeting. I think we're on the basis, we understand that the police may be concerned that some of the evidence could compromise future court action, but we haven't been persuaded, and we think they should take that into account in deciding what evidence to present. Now, am I seeing a hand up from someone from the police?
So you're not, but the exemption that we asked for relates only to the CCTV, and that was a request from the officer investigating the Section 18 on the 15th of October as a criminal investigation into GBH. And that specific request is to bear in mind the fact that the suspect in that offence has yet to be identified and traced. And so clearly this committee would want to be very careful to do anything that may potentially prejudice a criminal investigation. So it's simply the playing of a very short period of footage that would be the part that we would wish to exempt from that. You've seen the anonymous victim statement. There are no details there. It's simply the CCTV.
Amanda, have you got any suggestions how we can handle that?
Well, either we show the video towards the end, or because we'd have to ask that person to leave the meeting at some point. So in order to show that video, so it's when Mr. Ladenburg feels it's the right time for us to show that video, whether it has to be done at the end or nearer.
Okay, and is the other person here?
That's me, I think.
Okay, so would you be happy? That would give you a chance to give your evidence.
Yeah.
But it means, we're protecting the police evidence, and if they do, essentially it's about witness identification.
Yeah, absolutely. Yeah, I'm more than happy to leave and rejoin. Just let me know.
Okay, thank you very much. I think that addresses our problems, does it not, Amanda? I see you've got
Yes, Chair. I just wanted to say that if we are going into exempt session, we need to stop the recording of the meeting, so that it doesn't go out as a public meeting. So you'd need to decide when that's going to be done.
So may I suggest it's right at the end, not least because PC Giles is on her mobile phone and would need a bit of a pause in order to arrange that with your committee.
Okay, so the exempt area is purely showing the video again, which we saw at the expedited hearing, and we're going to do that right at the end of the meeting, and so it becomes an exempt meeting at that stage, and that is when we turn off the recording, we turn off the live video. Yes, I've understood that correct.
Yes.
Yes.
Thank you.
Okay, thank you. Paul, taking a while to get started today.
Chair, I think Sarah Clover has a question.
Sarah Clover.
Thank you, Chair. The only representation I've got from a third party is from residents of Bayford Street, Appendix E. If Mr. William Davis is the person that I've identified as the person who wishes to speak, that's not been notified to me. I wonder if there's a Regulation 8 notice.
You're using technical stuff that Amanda's going to have to explain to me. Come on, Amanda, what's this about? First of all, Mr. Davis, what's your connection with the written objection we received?
Yeah, I'm resident of said Bayford Street.
And is that okay, Amanda?
Well, my understanding is that all the parties would have been notified about the local residents' representation. So I'm surprised that it hasn't been passed to Ms. Clover.
I've got the letter at Appendix E, which says, "We are writing to you as residents of Bayford Street." It's anonymous. And I'm wondering if there's a Regulation 8 notice for Mr. Davis.
What does that mean? My understanding is
Well, no, there isn't one. I haven't got a Regulation 8 notice for him. No.
So the copy that I'm looking at is clearly had a whole load of signatures on, and they've been blacked out. They've been redacted because it's not our normal practice to put people's name in the domain. What is your problem?
Well, according to the hearings regulations, if you don't notify the committee in advance through a Regulation 8 notice that you're planning to speak, you have no entitlement to speak. It's a procedural point. If the committee wish to overlook it or disregard it, it's a matter for them.
Ms. Clover, it's not a case that Mr. Davis didn't notify the members that he was going to speak. I think the licensing service notified the members of his intention, and the papers would have included his representation that they were sent. So they are aware prior to today that he was going to be speaking. So although there's not a Regulation 8 specific notice presented to them, they have had notification.
It's the first I've heard of Mr. William Davis's name. I'm raising it as a procedural point, as I'm entitled to do. If the committee is satisfied that they're proceeding legally, I have nothing else to say.
Mr. Chair, would you want to comment on this?
Just to clarify that Mr. Davis returned his notice on the 3rd of November in accordance with the hearings regulations. So we can assume, therefore, that it's perfectly okay to hear from Mr. Davis. That's what I'm hearing. Do other councillors here agree with that? Thank you.
Yep.
Lovely. Thank you, Councillor Smith. Okay. So we will proceed. If I can just explain something about this agenda. We've ended up with 3 separate sets of papers because we have 3 separate licenses that we're being asked to review. It's quite honestly bad practice that when a license is updated, we don't take away the old license at the same time, but it appears not to have happened in this case. So what we have is 2 licenses, the sort of previous one and the current one, for the Dolphin running side by side. We also then have the third one, I think, considers the wine bar next door. Premises here. The wine bar next door, as I understand it, is actually an overflow area from the Dolphin pub itself. So in practice, we're considering the same incident and its implications for what are in effect 3 separate licenses. As I say, that's kind of unusual because we normally replace one license with another. We wouldn't have 2 concurrent licenses on one premises. But that's why we've got them there. We will have to do a separate decision notice for each of them at the end of this meeting. But I am minded to take the evidence. The evidence is
unless somebody can give me a convincing reason not to do so, the evidence seems to me to apply to all three. And I guess what we'll have to do is we'll just have to say at the end of the of considering the first review application, when we come to the second two, we'll have to ask, are there any circumstances that apply to this particular premises that have not been considered in the evidence given on the first of the premises? Have I understood that correctly, Amanda? Yes? I think you're happy with that.
Yes, that's correct. Yes.
Okay. And we're going to do the exclusion resolution at the very end when I mean, that I'm not quite sure how we're going to do that. I've got to be honest.
I think after the closing of the do you want to do it at the closing remarks or before closing remarks? That's the thing, I suppose, at the end of the discussion phase, maybe? Or do you think at
Yes,
the end of the closing remarks?
I mean, having seen that video before, I don't see that it would impact on the closing remarks. Both Councillor Smith and I have seen it before. Councillor Bell was not at the first expedited hearing, so it's extra information for Councillor Bell rather than the other two of us. So if that's all right, then that's what I will do. Absolutely, we'll do the closing remarks, and then so as Councillor Bell has got all the information the rest of us have, then we will just run through that video. Is that okay?
Sure, I'm happy with that. Just to be safe, however, I think you'd give the council on both sides one last chance to comment after it's been shown, just in case.
Okay. Are we happy with that? Who's going to advise me on that? Guy?
No, that should be fine. I mean, I think just asking the two representatives if they're happy with that, that would be fine.
Okay,
So I'm happy with that. Yes, I'm happy. Thank you.
And Helen?
Sarah?
Helen?
My name is Sarah.
Oh, sorry, I'm muddling people up. Sorry, Sarah.
I'm not entirely sure what it is you're inviting us to do. At the end
What
of
we're
this.
suggesting is because the evidence that the police want exempt is the video of the incident, yeah? And the talk is that we put that on at the very end after the summing ups, but we do allow counsel for each side to view it and then add comments if they feel comment is needed. But apart from that, we're asking everybody else to leave the meeting. So that we think includes everyone with a possible view, but protects the police evidence. Is that okay?
Yes, that's true.
Lovely, thank you. Right, I think we're ready to start then. So, in the first instance, we are considering the first of the licenses on the agenda for the Dolphin 165 Best Street. Can you please outline?
Oh, sorry, Chair. I do apologise. I know we've had a lot of starting up, etc., but I'm not sure that you've gone through declarations of interest, etc., at the beginning.
No,
of the
I think you're absolutely right. I'm being thrown.
Sorry about that. It's just I know we've been caught up with the procedure of setting up how the
okay. Well, now first of all, yes, and we haven't introduced everyone either. So let's do that to start with. So, who is going to be putting the applicant's case today?
So I will. Guy Lardenberg, Counsel for the Metropolitan Police. PC Giles is here to answer any of your questions about what's been happening.
Thank you very much. Responsible authorities case, that will be environmental protection today. Who's going to be putting that case? Please introduce yourselves.
George.
My name is George Walkerite. I will be putting in the presentation for that.
And you're on your own today, are you?
Correct.
Thank you very much. And then in terms of other persons, this is what we were having a discussion about earlier. We have Mr. Davis. Do you want to say hello to us, Mr. Davis?
Good afternoon, councillors.
Lovely. Make sure your mic's working. And there's nobody else coming, no? And none of the other signatories on that letter. Did you hear me?
Sorry, I didn't realize that was addressing me. Other residents of the building asked if I could speak on their behalf, but due to childcare and work commitments, I'm actually the only one who could make it.
Thank you very much. And where have I got to? And then who is going to be speaking on behalf of premises license holder.
Chairman, as I explained at the beginning, good afternoon, Sarah Clover. I'm the barrister for Yasser Yildiz, but one of the premises licenses is in joint names, as you will know, and so Newit Yildiz is not represented, so far as I'm aware, is not here. She's been notified. I raised it as a legal point earlier.
Okay. But we were advised we'd done the necessary and we could proceed anyway. Thank you.
I'm Helen Ward. I'm from Poppleston and I'm a solicitor for Yasser Yildiz, who is one of the joint premise license holders, and Yasser is here with me as well. We also have another solicitor from our firm, Felix Faulkner, who is here on behalf of the premise license holder, Yasser. But as Sarah said, it's only Yasser, not Nuvit, the other premise license holder.
Okay, thank you. And is there anyone else here who I've missed in these introductions? No? Good. I'm sorry, it's always a bit challenging doing things online. I'll try and do my best, and obviously time has slipped already, so let's just crack on now. So we'll start with the first of the
Chair, sorry, just to confirm, I have no declaration of interest to make.
Declaration of interest. I have nothing to declare either. No, go on.
Okay, thank you. Thank you.
Nor have I.
No declaration. And basically, that's why we say which wards we represent, because we wouldn't normally consider applications within the wards we represent. So we're all compliant with that rule too. So, Suba, do you want to introduce the first one? The review of the license of the bar itself. Thank you.
Thank you, Chair. This statement covers all three licenses. The licensing service are a receipt of an application from the Metropolitan Police for a summary license review under Section 53A of the Licensing Act 2003 in respect of two premises license at the Dolphin, 165 Mass Street, and for the Dolphin Wine Bar and Restaurant, 163 Mass Street, following an incident of serious crime and disorder which occurred in the early hours of the 15th of October 2021. At the interim stage pending the full hearing on the 15th of October 2021, the decision was made to suspend the premises license with immediate effect, pending the full review of the premises license to protect the members of the public and to allow the police to investigate the serious incident, in addition to the failure to comply with the conditions of the premises license. Representations remains from environmental protection and other persons who are in support of the review. We have received statements and evidence bundle from the police and the witness statement from the premises license holder. All these documents have been circulated. I have nothing else to add. Thank you, Chair.
Thank you very much, Suba. Do we need any clarification on that from either Councillor Smith or Bell? Perfectly clear to me. Thank you very much. Okay, so next one is the responsible authorities. Hang on, so can we please hear from the police? What is the case from the police?
Yes, sir. Thank you very much. As I said earlier, when the GBH happened that you've already considered in the interim steps hearing, the police had already submitted a standard review in relation to long-standing non-compliance by Mr. Yildiz in respect of 165, 163 Mare Street, the Dolphin. So, and as you say, it operates as one premises, and it's a bureaucratic confusion that there are three licenses for this. The first two licenses, the conditions are identical. New conditions were added, but it's broadly similar to the one that was granted in October 2019. And you'll see some of the evidence precedes that. And I know that it may be suggested that this is a clean slate and you shouldn't see anything that goes before 2019. But you'll see evidence in our bundle of non-compliance going before 2019 and into 2021, culminating in the serious incident that you've already heard about in October. And so when this committee granted Mr. Yildiz the license in October 2019, they urged him to remove the old license and his estranged wife from the original license and make a single application for a single premises license. I don't think that the numerous conditions is the cause of the confusion that's happened at the Dolphin. life very difficult for you. So the main evidence that we rely on is PC Giles's long 12-page statement that you've seen, and that refers to a number of appendices, again, which are all in your bundle, which unhelpfully hasn't been paginated, and we apologise for our part in that. But J in your bundle shows all the appendices, and I'm not going to go through the 2019 non-compliance in any detail at all, but you've seen there were police visits in 2019, 4 of them in April, 4 of them in May, a series of closure notices requiring Mr. Yildiz to resolve breaches, all under the threat that a criminal offence may be committed, and all under the threat that the licence might be reviewed if he gets his house in order. And so you will have noticed, and your colleagues, recurring themes in failing to abide by these conditions: loud music, insufficient number of security staff, or if there were enough on duty, confusion about what their exact role was, the scanner repeatedly not being used or not being used consistently with the condition on the licence, no training regime, and really a chronic lack of familiarity on the part of Mr. Yildiz and his staff about what the conditions on his various licences were. And this sad history, although it was succeeded in October 2019 by that new licence, has been repeating itself after the premises reopened after the first lockdown. You will see a helpful statement from PC Perry in relation to the very second of those visits back in 2019. The management of this premises has shown contempt not only to the police but also to Hackney Council, who issued the licence. These are not isolated one-off breaches that have been rectified. They are a continuous pattern of behaviour showing a total disregard for their responsibilities. So that was in early 2019. And we say, unfortunately, that pattern of disregard of the conditions has continued into 2021. You'll see in respect of 2021 from PC Giles's evidence and PC Ryan's statement that you already have, they visited and found numerous breaches of COVID rules, and a COVID prohibition notice was served. If it was just that and the premises otherwise in happier times ran a tight ship, we wouldn't be here. But it's again symptomatic of the failure to abide by the responsibilities and conditions that their license is restricted by. And they were written a warning letter, similar to many such letters they were receiving in 2019, explaining their responsibilities, explaining the gravity of the matter, and warning them of consequences if they failed to get their house in order. Those visits you see continue in May of this year. You've seen meetings between licensing officers from the Metropolitan Police and the premises licence holder. And again, the recurring theme, which I don't need to take you to, but it's of Mr. Yildiz not really appreciating the importance of the conditions, or sometimes what they were, or even what the licensing conditions amounted to. So you have a wealth of material there, which in my submission is capable of demonstrating that Mr. Yildiz, despite repeated warnings, continues this objectionable pattern of failing to abide by the conditions of his license. And it was really that very, very long history of non-compliance that led to the standard review being submitted at the beginning of October. And since then, sir, as you know, there was an incident of grievous bodily harm in the pub in the early hours of the morning on the 15th of October. You've seen the anonymised witness statement of the victim. This was a nasty glassing in the bathroom of the pub, and the assault continued in the main part of the pub over the pool table, with numerous witnesses, Mr. Yildiz on the scene. And you will have noticed from PC Skinner's evidence, that's at H of your bundle. He was one of the officers who attended the scene. He notes, and I invite you to find, that the call to the police had not come from the premises licence holder or DPS as it should have done, pursuant to their condition 12. In fact, it was the ambulance service who contacted the police. That caused a 10-minute delay between the incident and the police being notified by the ambulance, which was an important period of time in that context. PC Skinner also noticed that the victim hadn't been properly attended to before the police arrived. There was no evidence when the police arrived of any SIA door supervisor presence, and certainly there have been no attempts made by the venue or the multiple security staff, if they were on duty, to detain the suspect or to identify any witnesses. And so you'll see from the CCTV that this assault was witnessed by many people indeed. The bathroom, which was the locus of the glassing, had been mopped and cleaned up before the police arrived. And even if there was nothing sinister in that particular cleaning up, it just shows the level to which the venue cannot be trusted to deal with an incident of serious crime and disorder in a responsible way that's commensurate with all the conditions that they have. Mr. Yildiz, you'll remember on the CCTV, which we'll see, is shown in the footage being told about what had happened, having a swig from his drink and then walking in the opposite direction to the suspect and the victim to the assault. And again, we say that's a rather graphic illustration of Mr. Yildiz's failure to cope with incidents of this kind. And you'll notice that PC Skinner concludes that the police investigation into the offence was made extremely difficult, resulting in police having to spend weeks identifying a suspect who could have been, and I dare say should have been, detained on the scene, and also failures, again, with the ID scanners, security staff, and CCTV, all of which are repeated problems at the premises over the last 2 years. So you'll have seen lots of CRIS reports from 2019 and 20 and 21. They run to many hundreds of pages. I'd like to put that briefly into context. The thefts that happened from this pub, all big pubs in Hackney will have problems with thefts over the years, and it may be nothing to do with the venue. So that evidence doesn't really help you at all. What the police do point to is two offences. One is the sexual assault on the 26th of September, and you'll see the CRIS report in your bundle B at page 96. There was a sexual assault whereby the suspect grabbed a female customer aggressively in the crotch area. That report to the police was made by a friend of the complainant. It was not identified to the police by the Dolphin, even though it's perfectly clear from the CRIS report, page 123 of that bundle, that the venue were told about this incident, and yet once again, like a few weeks later with the GBH, they did nothing to inform the police. There's also an incident of actual bodily harm on the 5th of September. Again, that happened outside the Dolphin. It's clear from that CRIS report, pages 83 and 84 of your bundle B, that staff from the Dolphin would have been aware of that contretemps outside. And once again, the police weren't informed by the Dolphin. They were informed by one of the victims coming to the Tottenham police station later on. And so whilst those two additional matters, the sexual assault and the ABH, may not be the most serious offences of their type, they do demonstrate this pattern of failure to engage with the police and failing to act properly when incidents of serious disorder happen. And what I would invite this licensing subcommittee to ask itself is, if there is a serious crime or an incident of disorder that happens at the Dolphin, can this subcommittee have any confidence whatsoever in the current management and current premises license holder to act responsibly? And I'm afraid, and one will naturally have sympathy for Mr. Yildiz and the marital breakthrough that he's gone through. There's been a very long track record of him not doing a proper job at this premises. And as a result, the licensing objectives are not being properly served. And the most recent incident that gave rise to the interim suspension was a serious incident of criminality, grievous bodily harm, where the police investigation has been seriously prejudiced by the inaction and irresponsibility of Mr. Yildiz and his team on the night. The proposal to replace Mr. Yildiz as designated premises supervisor by his number two, Yasminine, the police have considered that, but it's the same operation, it's the same management. And really, as long as Mr. Yildiz is the premises license holder, and as long as the police take the view that he is simply not up to the job of running a premises of this nature, the only option available to the police, I'm afraid to say, is to invite this committee to revoke the license, because it has been shown not to work in a serious way over 2 years, 2.5 years or more. So in ordinary circumstances, the police would be looking to identify areas of common ground or identify areas on the license that could be changed. I'm afraid the problems emanate from poor management, weak management, and Mr. Yildiz has not been able to do what he ought to have been doing, notwithstanding many, many warnings, many interventions by the police, many instances of enforcement. And so that's why we invite this subcommittee to revoke the license, so as to prevent the history repeating itself yet again. So that's all I wish to say by way of overview, and I'm very grateful you've given me longer than 5 minutes, but I hope you can recognise why that was helpful. PC Giles can answer any questions that you have, and I hope I'd answer any questions as well.
I think that was helpful, because you're right, it is a very big bundle and quite easily get lost within it. So pointing us to some of the key documents is important. I'll just make it clear though, I do think on consideration, you've had 12 minutes. If Sarah Clover wants 12 minutes, then I think it's only fair that I give her that. But first of all, any questions from other members of the committee? At this stage, we're just looking for clarification on the reasons for the police application. And you don't want to draw anybody else from the police at this stage, do you?
No, but PC Giles has the most intimate history with the premises for a long period of time. So the questions in terms of operational questions are best addressed to her. I can assist you with any points in relation to what I've just said.
Okay, so Councillors Bell and Smith, any questions on what's just been said?
I'm happy at the moment, thank you, Chair.
Councillor
Yeah,
Bell?
I'm happy to leave it to the discussion phase to raise some matters.
Okay, thank you very much. And so the premises license holder and their representatives. Can I assume, Sarah, that you're doing this on your own and you can call people if needed? Is that how we're handling this?
Yes, Chair, I'll take the 12 minutes for myself, if I may, and thank you for that. And if the committee have any questions for Mr. Yildiz, then obviously he's available to answer those questions. I'm not going to draw him in to the representation.
Okay, on my watch, which is a bit fast, it's 53 minutes past at the moment, so far off.
Thank you. I'm going to start with the incident that really brings us here from the 15th of October. We need to get some accuracy here, because the police are relying on a number of elements about that incident to point the finger of blame at Mr. Yildiz about that. One of them is that nobody from the premises called the police. That's not correct. The police statements say it was some 20 minutes after the assault before anybody did anything and the police arrived. That's not correct. So a number of these allegations are factually inaccurate, and you can actually see that from the CCTV, which you're going to see later. The incident itself, the actual assault, occurs at 01:54:38. You may want to take a note of that. The police statements say they were notified on the radio at 0200 hours. They were notified by the London Ambulance Service, and so there was a delay in there as the call was relayed, and it all occurs within 6 minutes. They're on the scene within about 6 minutes, certainly about 6 minutes. The timings are wrong. And I invite you to look at that, because there's quite a lot of allegation against Mr. Yildiz as to what happened in that space of time. In that situation, we've got the response and the reaction of the licensee and of his staff. Sean, a member of the SIA staff, called the police. Sorry, forgive me, my cat is trying to get out. That's the noise. The police allegations are that the suspect is still at large. That may be the case. It's difficult to know why that is the premises' fault, because the staff have identified the person that they understand was involved to the police. He's also on CCTV, and the CCTV was available at the scene, and the police watched it in some format at the scene. So we do need to look very carefully at this incident and what the premises did or did not do about it. Of course, one of the things Mr. Yildiz says about it is that they're not experienced with incidents of this severity. Now, that has had some downsides in terms of their crime scene management, but it's a positive in terms of the licensees, Mr. Yildiz in particular, have had the premises, have had the Dolphin for 18 years. So the incumbency of Mr. Yildiz and his wife at the time that they were getting on goes back some significant time. They've held this license since 2003. And I'll speak in a moment or two about the changes that came about in 2019. But you've got a very long history of trading at these premises without serious episode, without serious incident. It's not trouble premises. It caters primarily for regulars and locals. It's not renowned for being trouble premises. It's not had a long catalogue of criminality, disorder, fights, violence, that kind of thing. The police have obviously brought to you what they are aware of within the relevant period of time, and it is relatively little. Just looking at the 3 other incidents that the police draw to your attention, so effectively we're talking about 3 other incidents of violence and then this incident in October. The 3 other matters that have occurred between 2019 and now, the sexual assault actually, although that was the nature of the allegation, is unsubstantiated. And what the CCTV showed, according to the crime log, was the alleged victim punching the alleged perpetrator. Now, there is still some uncertainty as precisely what happened there. And for Mr. Ladenburg to say, well, the premises didn't notify the police, it is not always the case that the staff at the premises know about these things. And although victims and others, witnesses say, well, we told the premises, that may or may not be correct. So I'd invite the committee to have a certain amount of scepticism as to what it is that the premises staff can or cannot know, do or do not know, purely based on an assertion that a third party makes. If matters are caught on CCTV, that's a different matter, but that's not what's being suggested to you. Similarly, the other 2 allegations of assault, if you look at the crime reports, if you actually look at the CRIS reports, you will see that, again, they are unresolved. The outcomes were uncertain. They weren't brought to a criminal conclusion of some description. And so to a large extent, they are at large in terms of the allegation. That they were not concluded. So those 3 elements are the only other allegations of this type and nature that Mr. Yildiz has faced in all of this space of time that he has been trading. It is positive to note that the police concur that the allegations of theft really do not take this particular case very much further, because the police agree that for premises of this nature, this is not an unusually high number, regrettably, but it's a fact of life, of the theft allegations that are made. And again, we have to bear in mind that some of those allegations are not actually theft. They're people dropping things and losing things and then making a claim about it afterwards. So comparing the Dolphin like for like with other premises that you may be aware of in the area, other premises in the borough or the locality, it doesn't have a troubling history of serious crime and disorder, serious violent crime. What seems to have happened is that there are some notable examples recently which have understandably troubled the police. However, for the police then to say, as Mr. Ladenburg just did, that this is a pattern of behaviour over the last 2.5 years is not fair, because of course we've had COVID and the COVID lockdown. So the premises have not been trading in excess of a year. Everybody went into lockdown, as we know, in March 2020. Mr. Yildiz is candid about this in his statement when he says that they struggled to understand the ramifications of the COVID regulations. And quite frankly, I think that was an experience that most of us could at least relate to. And so his reaction was to attempt to open, to find that he struggled, and then to close again. So he was really substantially closed for in excess of a year. And he took the responsible course, one might think, in finding that he wasn't reacting very well to the COVID regulations, simply to close the premises in their entirety. And that is what happened. He had further meetings with the police. In July of 2021, he agreed to step down as DPS, and Yasmin Akyol was agreed to be his replacement. And at that time, the police didn't have any objections or concerns to Yasmin. So one can assume that in terms of a transfer of management and responsibility, that was acceptable to them at the time. And that is still the situation now. Yasmineen Akil is available to be DPS. Sadly, she was unavailable to be here today because she is out of the country. Now, the last police visit to the premises was in August of this year. The review application, the standard review application, took place in October, and then shortly afterwards, on the 15th of October, we had this particular incident. I just need to say a few words in relation to noise, which is a separate issue in my submission to the committee. And if the committee is looking at the most serious elements of this case and looking at revocation, noise really sits alongside it. And I don't understand that the environmental health team are asking for revocation. Indeed, they almost could not be, because they have served a noise abatement notice, which is challenged for various reasons. It would be my submission, it's not for the committee today, but it would be my submission that the statutory noise threshold legally is not passed in this case. We have two allegations back to back on two consequent days. Measurements been taken in cars, at traffic lights and so forth, which would not pass the test. Be that as it may, that's all for the noise abatement notice appeal. The appeal is in. But in the context of that, environmental health are not asking for the license to be taken away or the business to be closed. They're asking for the nuisance to be addressed and debated. Now, that is capable of doing, and it wouldn't require a final closure of the premises. And ultimately, I'm here today to attempt to dissuade the committee from closing the premises in their entirety. As far as this area is concerned, it is a vibrant and noisy area generally, and the committee will no doubt know that. There is a lot of pedestrian traffic, there are a number of takeaways here, there are a lot of vehicular traffic movements and so forth. In terms of resident complaints and what you may hear from residents, Mr. Yildiz had some initial complaints about the dolphin from residents back in 2003 when he first opened, and he's had no complaints since, and that's up to date. Now, it may well, the patrons of the dolphin have never behaved any differently. They've gone into the garden, they've used the beer garden and the facilities and so forth, so nothing has actually changed. And we do also have to note that in 2019, obviously, when the application came before the committee to grant a new license, Mr. Yildiz alone, so that he was separate from his wife, and the committee will know why Mrs. Yildiz is still on the other license. I can't assist in that regard. But at that time, recorded music was added to the license. So up till 2019, it had been background music only. The application in 2019 was to add regulated entertainments, and the committee acceded to that request and added it. In terms of anything that happened prior to 2019, whether it is crime and disorder, whether it is allegations of condition breach or anything of that sort, my submission is that it doesn't help the committee to go back any further than 2019, because all of those matters were canvassed at that time. There are disputes about breaches of condition, numbers of SIA. Both of the premises have different license conditions, but have always had their SIA requirement counted together. For example, there were allegations of people outside when the premises claimed that they were closed. All of that was canvassed at the time of the 2019 license, and the committee was satisfied and granted not only a fresh license, but an extension of it. So I would submit to the committee that it would be dangerous now to go behind that and make findings against Mr. Yildiz for anything that happened prior to the grant of that license. And it's notable that there was an environmental health objection at that time that was withdrawn, and the addition of music was granted. So that gives you a post mark as to how neighbours have or have not been affected by the dolphin, and over what period and in what way. And as again we say, since 2019, there's been a relatively short period of trading because of the COVID lockdowns. That, as it happens, has.
Can you've had 12 minutes. Can you draw to a close now, please?
I am now doing. I wanted to simply make these final observations. The COVID pandemic has had an impact on residents and also on operators. Residents find themselves very sensitive to noise that perhaps they were used to previously. And finally, as far as Mr. Yildiz is concerned, these are not just his premises. And I've just touched earlier on the employment opportunity that they afford. The Dolphin is iconic in this location. It's a well-established institution in this vicinity, very popular with the locality. If it is closed, it will literally be a dead frontage. This bespoke building that's such a popular landmark will be no more. And that is a serious implication for the economy, which is not to be disregarded. We've got Court of Appeal case law, which indicates that the local economy is also part and parcel of the committee's consideration. And I do ask the committee to consider all the alternatives. Mr. Yildiz is quite prepared to engage in the changes that the police were discussing with him back in July. He has averted in his statement to the complicated divorce that he's been going through. Angus, you've heard mention of the general manager who has had an alcohol problem.
You are continuing beyond the 12 minutes that I allocated.
I am, Chair, and there are reasons for it.
Can we can bring this up under discussion if it's relevant, but I think it is not of such direct relevance as the points you made earlier.
Okay, if you're cutting me off, Chair, then so be it.
Thank you very much. Can I just ask a question for clarity, and then I'll invite my colleagues to do the same? And we can come back to the police on this afterwards, obviously. I mean, that is quite a key difference in what you're reporting and what the police are reporting. In what you're saying is that the licensee has identified the person believed to have done the glassing incident to the police. Now, I've seen that video previously and I saw a person on the video, but I didn't know who that person was. Are you suggesting that that they've simply pointed out that person on the video, or have they provided name and address? Have they provided evidence of where he lives and all that sort of thing? Can you explain that to us?
My instructions are that members of the staff know who that person is and have given those details to the police.
Okay, we can cover that in discussion. At this point, it's clarification. Let's try and stick to the rules. So it's clarification on what exactly is meant. Councillor Bell, Councillor Smith.
I'm content. Thank you.
Councillor Bell? You might be on mute, I think. You are on mute.
Sorry, I was just saying again, I'm happy to come back to everything in discussion phase.
Okay, where have we got to? I'll dig out my procedure.
I've just had a clarification.
Right, I think we're now ready for discussion. Can I just? I think the obvious thing.
Chair, I think it's the authorities next.
Oh. Yeah, we still got the authorities, haven't we? Yes, environmental protection. Sorry, George.
Thank you, Chair. Can you hear me?
We can, yes.
Okay. I joined ACME in 2017, and as far as I know, we've been receiving complaints about the dolphin. Various noise complaints have been ongoing. It's not a one-off. It's something which has been going on for quite a long time. I remember when we had a joint visit with the police in 2019, just before the review, I witnessed excessive and extremely loud noise. The police asked me to put in application to support them. I didn't, simply because I wanted to give the premises a chance to rectify things. I'm coming on this occasion because I've taken over the ward since May and I've received several complaints about noise. What happened is, I've spoken to lots of residents. Some of them live about 50 meters away and they can hear the bass coming from the premises. On the 4th of September, 2021, at 2 a.m. in the morning, I was on duty. I visited the premises. I went to the back. I witnessed extremely loud music, the bass especially, and the voices at the back coming from the temporary structure. And I went to the front and I got Mr. Yildiz and his staff. We came to the back and we had a long discussion. I brought it to his attention. He agreed that the noise was a problem and that he was going to get an acoustic consultant to give him the quote so he can sound insulate the property. The reason why there's a lot of escape, and I explained this to him, is an old building. The type of music he's playing has got heavy bass. Heavy bass has low frequency noise. Now, low frequency noise penetrates anything. An example I can tell you is that during the Second World War, when they dropped the bomb in East London, the people in Essex couldn't hear it, but the people in Norfolk heard it. So sound bends. This is the reason why people as far as Mantmore Terrace are complaining about the noise from the premises. It's extremely loud. The building cannot contain this noise. And that is why there's an escape. So I spoke to him. This was on the 4th of September 2021. And we
Chairman,
discussed.
I'm so sorry. I'm going to have to interrupt. I do regret it, but most of what Mr. Walkerach has said is not in evidence. It hasn't been disclosed.
Actually, may I just say, Sarah, I realise I've slipped up on the order here, so I was going to allow you a chance to come back and respond to these because that's only fair, obviously. Hopefully, Amanda, that allows us to carry on safely, despite the fact I've slightly messed up my order. We don't do many reviews, and I've slipped up there. Is that okay? We hear
Chairman,
this evidence now.
Forgive me.
Chair, can I just clarify? I don't know if you understood what Ms. Clover was saying. She's objecting to this evidence being given because she's saying that it's not been presented in advance. Yes. So I don't know if you want to ask the officer why that is the case, why he's presenting evidence that's not.
Thank you very much. And on that general point, is it if I can accept responsible authorities now, I can accept other persons now, but it's only right and proper that I then go back to Sarah to have a chance to counteract from the licensing. Is that okay if I do it that way around?
Chair, I don't know if you've understood, is that the Environmental Protection Officer is in the middle of his evidence or his.
No, okay. You want to advise me that on the end? I'll come back to you at the end. Sorry about that, Amanda. Okay, so yes, George, the evidence that I've looked at refers to some very specific incidents, and it's being challenged that you're now bringing in evidence of a history of complaints, wider history of complaints. So. Have you submitted that to us in advance?
No.
Okay, can I suggest that we can raise our concerns under discussion, then you can refer to that more widely, but it possibly is inappropriate to raise it here. So here, can you keep yourself to the specific incidents that were reported in advance of this hearing?
Chairman, forgive me, I make it absolutely clear I will be objecting to anything additional coming in at any stage because it hasn't been disclosed in advance. You require 4 or 5 days in your regulations, but in any event, it's a regulation 18 point under the hearings regulations. I don't agree to it.
Okay, I will be taking legal advice at the end of George's evidence, but if you continue, George.
Thank you. Okay, I won't go back. The reason why I was bringing it is to give you an overview, but that's fine. Okay, on Saturday, the 2nd of October, we visited the premises at around 1:49. We went to the back of the premises. I was with my colleague, Bianca, and on arrival at the back of the premises, we witnessed extremely loud music and voices, and in our opinion, the noise was extremely loud in the street, that even if we'd been in a nearby property, it would have been a nuisance. So we spent about 15 minutes taking notes, and we drove through the back. There's a traffic light directly outside the premises. on Mayor Street. And as we were waiting for the lights to change, we could clearly hear the bass of the music from the premises with the window shut and the engine running. So we then went. The following day again, we came back and it was the same. We witnessed loud music and voices extremely loud on the number of occasions. So this is the reason why it's not a one-off. Mr. Yildiz has been made aware that there's been complaints. In the last 3 months, we've had 10 complaints from 5 different residents.
Chair, this is exactly what I'm talking about.
As we said, if George, you could point to places in your witness statement that you've referred to previous complaints, then I think it's acceptable to go into that. I'm going to take legal advice from Amanda at the end, but can you refer to your witness statement at which you talk about that wide level of complaint?
Yes, Chair, if the officer can just stick to the points that he's already notified the parties of, or the statement that he actually submitted.
Yeah. So do you want to bring your evidence to conclusion there?
Yeah, thank you. Again, I visited on the 3rd, and Mr. Yildiz found me recording the noise from the back, and we had another discussion. But the complaints continued the weeks after that. Okay, so in my opinion, I think he's a responsible licensee. He knows about the noise. What he could have done is he could have just turned the volume down and control the noise. It doesn't need any time to carry out any works.
Okay, is that your evidence? I mean, I can say I'm looking through this pack.
I can't hear you.
I'm looking through the pack, and if I look at statement appendix D, statement of witness, clearly there is a letter before us referring to a history of complaint, the letter that was sent to Mr. Davies. So I would have thought it is perfectly legitimate for us to pick that up in discussions, Amanda, and raise questions about that history of complaints. I'm looking at it on page 45 of the written agenda. So it has been raised. The wider complaints have been raised. Have I understood that correctly, Amanda?
Chairman, can I just comment, please, that my instructing solicitor, Helen Ward, has asked for details of the complaints in writing, and they haven't been provided to us. We've asked and we've been refused. So to bring them up now in the middle of the hearing would be an ambush.
Yeah, just to reiterate, we did ask in writing for details of all the complaints. They have not been provided, and we asked for this some time ago.
I think we promise anonymity to people who make complaints. I'm going to get further legal advice in a minute. So, I'd like to just ask some clarification questions first. So, Section 80 notice has been served.
Chair, Chair, you're breaking up a bit in terms of the microphone.
Oh, okay, perhaps I need to go further away, not closer. Is that better?
Yeah.
I think you just need to speak directly to your computer.
Okay, can I just specifically go, George, on the questions we were asked there? We've been told that the Dolphin is appealing the Section 80 noise abatement notices that have been served. My understanding of demonstrating there's a nuisance, which is the case with a Section 80 notice, is normally that has to be witnessed in a place where it be a nuisance to other people. And the street would not normally be regarded as a place where such a nuisance could be witnessed. Have I correctly understood that? And is what you're saying that that's not relevant to the fact that you and Bianca both saw a level of noise which you think inevitably would have caused nuisance in adjacent premises, sorry, adjacent homes?
Yeah, thank you, Chair. If you look at the Environmental Protection Act, it's very specific. There's a clause which talks about likely occurrence. Likely occurrence, For example, if somebody is setting up a music system, hasn't even played it, and I believe is going to cause a nuisance, I can serve a notice on likely occurrence to prevent the nuisance from happening. What happens is when you witness it in the street, the law gives us the authority to serve the noise on likely occurrence. And that is exactly what I've done. I believe it was loud enough in the street, even if I'd been inside the dolphin is surrounded by residential dwellings. Even if I'd been inside, would have been the same. Thank you.
Thank you. Okay, Amanda, right, other questions for clarification? Councillor Bell, Councillor Smith, and then we'll get some legal clarification. Councillor Bell?
Nothing at this stage, Chair.
Councillor
Yeah.
Smith?
Same, Chair. I'm happy to answer ask questions in the discussion. Thank you.
Okay, so Amanda, I've slightly muddled up my orders. Firstly, do you feel that the written evidence before us does allow us to get back and ask for the evidence of the wider complaint? And can you explain why, when Mr. Yields' solicitor asked for details of the complaint, why they were not provided? Can you just take us through that?
Is that for the officer, Miss?
Well, no, I was hoping you could tell us from a legal perspective.
Well, I'm surprised, obviously, if he was asked for this information, that it hasn't been provided, because they are entitled to ask for it so that they know the details of the complaint, so that they can actually respond to it during the hearing, because otherwise it is prejudicial to them, to their case, if their client's not had an opportunity to respond to complaints or to address them in some way, because they'll be taken into consideration as part of your evidence and the decision that you make today.
Okay, so they would be redacted complaints with the names and addresses removed. Is that correct?
Yeah.
Okay, so George, do you know why that didn't happen?
I got the email. I hadn't had the time to respond. One, because I have to go through the system and verify all the complaints. Secondly, they notified me of an appeal. I had the opinion that I would respond to that for the Section 80 appeal and not for the licensing hearing. I'm sorry if I was wrong.
Thank you, that provides clarity for sure. Then I'm going to come back and ask one more question, Amanda, which is the one about the order. I'm taking things in the wrong order. If I give the licensee's counsel a chance to interrogate this evidence at the end of hearing from the other person, can we still go ahead? Is this still the right way to conduct the hearing?
Chair, I don't know if you saw that message from counsel saying that he can't hear you clearly on your microphone.
I'm doing my best, and I have a nice big broad bandwidth. I can't do any more.
Okay. If you can try to speak into the microphone as far as you can. Thank you.
And so I asked a question then, did you hear that?
Sorry, could you repeat the question again?
The question was, I've slightly muddled up the order.
Yeah.
In that I hadn't taken all the responsible authorities and the other persons before taking the evidence from Sarah Clubber. So I'm saying I'm going to allow the other person to speak now, and then I'm going to allow Sarah Clubber to come back in at that stage and challenge anything she thinks is inappropriate. Is that okay?
Yes, that's fine. Yes, I think it's fair to give her that opportunity.
So,
can I just clarify, please? My name is Clover, like four-leaf clover. Can I just clarify that that doesn't include new evidence that we've just discussed, complaints, because I won't be in a position to challenge, because I'd need to take instructions on it. So anything that's new that doesn't appear in your bundle, can I ask for that to be kept out, please?
yes, I think that we've clarified that situation. I think I know what we can consider and what we can't consider.
I think she's saying that going forward, if anyone is presenting any evidence, they need to make sure it is in accordance with what has been presented.
Absolutely, and that applies presumably to other persons as well. So
yes.
Oh, we're getting there slowly, but I'm not doing it perfectly. I'm doing my best. So, William Davis, you heard what's been said. We
All
want
right.
evidence consistent with what was presented in the evidence before us. So can you back that up, please?
Yeah, sure. I mean, just from our perspective and the perspective of people in the building, it's extremely loud at night, in particular on weekends. It can be heard in the bedrooms of the property, and it's really loud. Like it stops us from sleeping. Myself, my partner, both sleep like on the weekends, sleep with headphones in to play either like music or I listen to white noise as interference. And even through that, you can hear it and you can feel the vibration within the bedrooms. Like we're not unreasonable. Like as a building, we've all written this letter, and we weren't like coming out seeking for them to shout. We just want them to turn it down so we can sleep. Like the people underneath me have 3 children, one of whom is like a young baby. They're entitled to be able to sleep. It's very frustrating to me that we can hear the noise at kind of like crazy late hours. I understand that we have proximity, but like to be clear, we're not next door to them. We're not on top of them. We're round the corner from them. There's like a relatively significant distance between us and them, and we can still hear the music within the bedrooms of the property. We just want it to be quieter, and we just want to be able to sleep at night. And the children of the building, in particular, of which there are 5, are entitled to be able to sleep. Is really not good for anyone's health, anyone's mental health, to be kept awake that late and to hear that noise at all hours.
About noise, you also refer to large amounts of waste and failure to dispose of waste properly. Is that also a problem?
Yeah, I mean, that's the people on the other building asked me to add that in specifically because there's a giant pile of rubbish bags behind the property, of which flies emanate and come in the building. Like they can't have any of the windows open, and especially obviously it's cold now, but when it's a bit warmer, you get a lot of vermin. Flies coming in, really not healthy. Again, there's children in the property, so yeah, I just don't see how that's acceptable.
Okay. Any questions from my fellow councillors? Councillor Bell, Councillor Smith.
Mr. Davies, in your written representation, you asked for a reduction in operating hours.
Yeah, that's correct. Yeah, that's correct. As I said, sorry, go on.
What type of reduction are you asking
I mean,
for?
during the week, one is too late, so I think we'd be looking for more like 11 or earlier, and on the weekends, like I guess like 12, which is sort of like around when everyone else in the area shuts. We want to be able to sleep. Like we're relatively young, but a lot of, as in we're young adults, but some of the other people in the building have kids, and some of them are older, and some people work weekends and stuff. Like I get that there's ambient noise coming from the kind of nighttime economy in the area, but there's nothing to this level which keeps us awake. Without that noise, there wouldn't be such a big disruption.
Okay, thank you.
Councillor Smith, yes.
Yeah, just on the waste element.
Yeah.
I presume there's a condition under the current license as to how they deal with waste. Is that right?
Is that question addressed to me, or?
Well, just in general, maybe to Suba. Suba, do they have a condition that refers to waste in their license? Sorry, say that again, Suba?
There are some conditions which has been agreed with environmental enforcement is in the license from 25, 26, 27.
Yeah. Can you just
and 28? Yeah.
Yeah. Can you just read one of them out?
So do you want to display those conditions on the screen?
Yes, please.
No.
I mean, I could possibly read them.
Yeah, that's what I thought we were doing, reading.
Okay. So I'm looking at the first of the licenses, which I hope is the same as the others. Okay, the licensee shall ensure that all staff are fully trained and made aware of the legal requirement of businesses to comply with their duty of care as regards the disposal of waste produced from the business premises. The procedure for handling and preparing for disposal of waste shall be in writing and displayed in a prominent place where it can be referred to at all times by staff. The licensee, that's 28, 29, the licensee shall ensure that any contract for general and recyclable waste disposal shall be appropriate in size to the amount of waste produced by the business. Condition 30, the licensee shall maintain an adequate supply of waste receptacles provided by the registered waste carrier, refuse sacks or commercial waste bins in order to ensure that refuse emanating from the business is always presented for collection by his waste carrier and shall not use unidentifiable refuse sacks or any other unidentifiable or unmarked waste receptacles. I could carry on, but those are fairly standard conditions.
Yeah, just a question then to William. William, having heard those conditions, what are your feelings?
Oh, I mean, they're in just unrecognizable sacks, and B, they're behind a fence, so like they're not on the street, so they couldn't be picked up at all. They're like on it's hard to say, hard to describe, but they're behind a fence in between the wall of our property and the wall of something that's connected to the dolphin, basically.
Okay, thank you.
Any more clarification required? No? Okay, so I've gone in a bit of a roundabout way, but Sarah Clover, apologies for mispronouncing earlier. Sarah Clover, do you want to come back on any of the stuff that we've heard there and say what's admissible? We've heard your general points about if it's not in the original statement, we shouldn't consider it. We've heard that.
Yes, just in relation to waste particularly, there was one line in the Bayford residents' submission about this. It's not been followed up by the responsible authorities, so we've had no input on this from environmental health or indeed trading standards should they be concerned. We've had no letters of warning, no letters from the licensing authority, and this is not accepted. The area that we're talking about is an open space. Lots of other people, including residents, put bins there. We're not really aware of what the nature of this problem is or why it's being evidentially connected to the dolphin by people who, at their own admission, live round the corner. So this is a bit of a curveball. I don't understand any of the responsible authorities to be inviting you to take steps relating to rubbish or waste. I think a number of people have had some difficulties with collection of waste during lockdown, truck drivers, so on and so forth. But I'm not, just to make it absolutely clear on behalf of Mr. Yildiz, I'm not accepting anything about waste, and I don't understand that to be before you at the hands of any of the responsible authorities. So I would be inviting you to set that to one side when you are considering your decision. It's not accepted.
Yeah, in considering our decision, we will note that Environmental Health Authority has the two parts of it have both said they're not making representations. Oh, sorry, the Environmental Protection has made the representation based on noise. Environmental Enforcement have confirmed no representation on that application. So we will take that into account. Thank you.
Yeah, on everything else, I don't think I have anything specific. You've heard what I've said about noise complaints. So if I get an opportunity just to make some final comments, I've got nothing else at this stage. Thank you.
Okay. So, councillors, can we go on to discussion now? Yeah. Can I just kick off? I think, first of all, I need to ask Guy Ladenburg where. Trouble is, if I look at the microphone, I start losing my way. So let me just call you Guy, if that's okay.
Yes, of course, sir, yes.
Right. Now, look, Guy, the substantial points of difference really are between what the licensee is saying and what the police are saying about the level of assistance provided both to the victim and in identifying the perpetrator. So
yes.
Can you give us chapter and verse on that, please?
Yes, I will, but then I'll obviously give PC Giles an opportunity because she's much closer to the investigation. In relation to the GBH on the 15th of October, my understanding is that the staff gave police a name and a number, a first name and a telephone number. The telephone number does not work, so far as we've been able to ascertain. I think PC Giles will maintain that police attended the venue on account of being called by the London Ambulance Service, and I don't think they have any record, which they would have, of the venue contacting them. That's in relation to the GBH on the 15th of October. You also heard submissions from Ms. Clover about the sexual assault on the 26th of September. Ms. Clover inviting you to be sceptical about the degree to which the venue was aware of that incident. The crime report I referred you to earlier, the relevant part is at bundle B, page 123, and that shows the police account that that had been given to them by the informant, on whose information they have to rely because there's nothing else at this stage, that the suspect was taken out by door supervisors out of the premises. And perhaps more troublingly, so far as cooperation with the police is concerned, police were given a short clip which showed the complainant retaliating against the allegation. At that point, PC Giles asked for further CCTV footage to show other areas and perhaps to try and identify the assault itself. You've got email correspondence about that in your bundle J at page 62 of 76. And I'm afraid to say that those emails which were directed to the absent proposed DPS, Yasminin, PC Giles has not had any response to those further requests in respect of CCTV. So I hear what Ms. Clover had to say, but from the police perspective, they have not been called on either of those occasions, and they have not assisted in the meaningful way in which the police would expect them to do so. I don't know if PC Giles wants to add anything to that.
I think it'd be good to hear from PC Giles. I mean, if she's able to help us.
Yep. I'm just trying to log on my camera. My camera doesn't seem to be working.
It's all right. Your voice will do. We can tell you there.
Oh, there we are.
Aha.
Hello. Yes, Guy has clarified perfectly. In regards to the sexual assault, it was myself that emailed the new potential proposed DPS and requested further CCTV because the only CCTV we got given was the victim hitting out at the suspect. From my understanding of reading the Chris report, that's a response to the sexual assault. She confronted him, then they went out, and that's when she told security and staff members, and police weren't called. So that's in reference to that. If I may just clarify the point made by Sarah Clover in regards to the calls made to police for the GBH, if that's okay, Chair.
Certainly.
So in my statement, PC Skinner's statement, and PC Flaherty's statement, Joseph Flaherty, we've all said approximately 2 a.m. It wasn't it happened at 2 a.m. It's not a case where we've got our timings wrong. It's all approximately 2 a.m. The call that we received from the London Ambulance Service was 020444. And as Sarah helpfully pointed out, the incident happened at 0154. I think it started in the toilet around then, and then it spilled out to 038. So we haven't got our timings wrong. It's just in our statement we've put approximately 2 a.m. But the call came to police from the London Ambulance Service at 0204.
Thank you for that clarification. Okay. Right. Other councillors, you've heard two different perspectives on what happened and the importance of these different incidents. Who's going to start the discussion? Councillor Bell?
You can go first, Brian, if you want.
Yeah. I suppose I need both police and Mr. Yildiz to comment on this. In our evidence, there was a meeting on the 20th of May 2019 as a result of the police's initial concerns about a number of possible licence breaches. Mr. Yildiz promised to draw up an action plan. What happened to that action plan?
Can I comment first on behalf of Mr. Yildiz, and if he has anything to add, then obviously he can, but it's in his statement, and he says that he regrets that he didn't do it because he was distracted by his acrimonious divorce, and I think that's the theme that's run through these proceedings. He's fallen out with his wife in a very hostile way, and they're fighting over a lot of things, including the dolphin. I don't know if he wants to comment further on that, but that point is actually dealt with in his statement.
Do you want to say any more, Mr. Yildiz?
Yeah, Mr. Yildiz would like to say something about that.
Hi. I've been in the last 5 years, my divorcing case been on the court case. And I've been in, several times, being a gang member, popping the dolphin. I got threatened several times, and I've been even in the police station a few times. They said they haven't done to you nothing, and that's why we can't help you for that. And secondly, I've been running in dolphin last 5 years my own self, and financially, all my finance is come up to zero, and I haven't got take not further action to develop the business, develop the pub, and I've been tied up last 5 years, seriously tied up, and I couldn't even move. I couldn't done nothing. I do give all my efforts and everything to dolphin. It's been a long time, and successfully 18, 19 years in the dolphin. And last 5 years, I'm in a hell of a difficult time and a difficult position. And I haven't got no time and no financially to prove myself. I can't even provide that, I can't even show how much millions of pounds run out. My ex still alive, because next week court case is coming, final court case. She's drained out all the finance from the account last 5 years. Eventually it's been, we go down to minus for the financially. Be a very difficult time, the paying securities and stuffs, and and the dealing with the customers, the kind of problem I was threatened, maybe someone after me, and it did actually happen a few times. They've been, trying to attack me as well, which been, she's been all behind this story, but I couldn't explain no one this, and all the situation, it comes all the way down in here last 5 years. Then I've been fighting with my life, fighting with my business, fighting with everything in the last 5 years. So it's a difficult time I'm passing through, and hopefully is everything get over it, and court will decide next week who's going to have the dolphin. And now when I'm like middle of nowhere, and sorry to give you guys this kind of problem, but as soon as I've been sorted out, and
Okay, is there any chance
Thank
you
you
can
very
answer
much.
the question? You had a chance, it seems to me, on 20th of May, 1919, that you could have sorted out many of the matters that led to this review. You promised to draw up an action plan with the police and then didn't follow through. Why?
Yeah.
Councillor Bell, if I may.
What was the, sorry, sir, what was the date and time, sorry?
This is the action
The
plan.
meeting on the
Action
20th.
plan, yeah. That's, I said the police, and we just waiting for the final court case, when we divided, and, I explained to them, actually, on the meeting, I said, like, when I finish on my court case, final court case, then I will take further action. I can get a new, member of staff, new security team and everything. I told them, just waiting for the final court case.
Well, our key judgment today will be whether or not you're a fit and proper person to continue as a licensee. And making promises and then not following through on them undermines your case quite strongly.
Give me, Chair, it's not a fit and proper test. That's taxis.
Now, in general, we're saying whether or not to revoke the license, we have to look at it, whether or not he agrees to things and then follows through.
And what I add to that, my concern is that what you're saying is you haven't had the capacity to effectively meet the licensing conditions. Now, are you telling us that when you get your final court settlement with your wife, when the divorce finally goes through, then you are going to have more resources and you're going to be in a better situation to manage the premises? Is that what you're telling us?
Yes, sir.
Anything more, Councillor Bell?
Yes, a few actually, but I still haven't got an answer on that one. Why didn't he submit the action plan?
Yeah, go on, Mr. Yildiz.
just waiting for the final case, final court case.
Yeah, sorry. That is covered in his witness statement. I think the impact of the divorce has left him distracted, which is why he said he did not submit the action plan.
Since this meeting, it's been 2 years since this meeting.
No, sorry.
Councillor Bell was referring to a meeting back in May 2019, I believe.
Yeah. Oh, sorry. The action plan in May 2019, he was closed shortly after. So the divorce has been going on for a very long time. The divorce has been going on for 5 years, and Mr. Yildiz, in his statement, addresses that this has caused him distraction, and that's from the witness statement. And then after that,
Can we just get the chronology right? Forgive me, can we just get the chronology right? Because we've got the meetings with the police in 2019, which culminated in the application for the new licence in October 2019. So any thoughts or promises or discussions about action plans prior to October 2019 would have been subsumed within the application. The police objections, anyone else's objections, and they did object, and then the committee's decision in October of 2019. So any submission of action plan prior to that, whether it did or didn't happen, was all dealt with at the time of the new application. Then we go into 2020, March 2020 lockdown, and it was in the middle of 2020 that there were meetings with the police and discussion of a further action plan and the change of DPS to Yasminine and the change of the security to Solar Security, which elements of that did happen, elements did not happen. Yasminine is in place, but she's not taken the transfer of the DPS. Solar Security is in, but there's been no written submission of an action plan in that space of time. Last meeting, August 2021. The last meeting was August 2021, and the review application was October 2021. So I think action plan missed is a 2021 issue, not a 2019 issue.
I disagree. He made an agreement with the police to put in an action plan, and he didn't follow through on it. And the fact that there was a later license application does not negate the fact that he made an agreement, didn't keep to it.
No, that's unfair. I'm going to kick back on that, because that isn't the way the police represented it in 2019. I don't know whether it was part of the acceptance that there would actually be a new application for a premises license to put him in sole responsibility and break away from his wife. So that isn't a fair allegation that there was no action plan submitted in 2019, because that wasn't part of the complaint of the police at that application.
It's in the police evidence. It wasn't submitted. It is.
Oh, that's not what they're talking about. They're talking about an action plan more recently. That the dates are different.
No, I'm referring to the 19 one.
Right. Well, I've made my position very clear on that. That wasn't an issue for the police in October 2019 when the new license was granted. That is not a fair allegation.
It was an issue for the police in May, and he agreed to produce an action plan, didn't do so.
I think I've understood the issue here. It might be helpful, Brian, if you were able to refer directly to where the evidence is, so Sarah Clover can come back and comment on it. But I think I understand the point both of you are making. Any other points, Brian?
So forward to May 21. Why is Mr. Yildiz saying that the license wasn't on display? Up-to-date version in the premises.
I think that's in his witness statement as well, isn't it? I think it's, again, it was an oversight, but I'm not sure that the police are asking you to revoke his license because the license wasn't on display.
They're alleging a series of breaches.
I think it's going to be very important to get a scale of seriousness here and proportionality. Nobody is suggesting that for any of these other issues that revocation would be on the table.
I heard from them that their key argument was a pattern of breaches, and it wasn't just about any one incident.
So far as the committee are concerned, what is important is for them to assess the risk to the public. There is no risk to the public of failing to display a correct version of the licence.
The risk comes from an alleged pattern of failures.
If the committee wish to revoke because of a failure to display a licence, no doubt that will appear in their reasons.
Yes, okay. Councillor Bell, anything else?
He also promised to change the DPS, and this appears not yet to have happened either. Is there a reason for that?
That is also correct. It's also dealt with in the statement. It's also dealt with in the witness statement.
Well, it's dealt with that it hasn't happened. Not quite why.
It's part and parcel of the same explanation that's been given throughout. I don't think there's any dispute or disguise about this. Mr. Yildiz has taken his eye off the ball in most recent times. He has relied excessively on the manager called Angus, who you will also note from the witness statement is dead. Very regrettably, it's been an incredibly difficult time. Angus is the man that the police have identified on a number of occasions as attending the premises and having an alcohol problem. Mr. Yildiz was aware of that. He wasn't aware of his health difficulties, and very unfortunately, the poor man is deceased. Mr. Yildiz has taken more time than might have been desirable to get this house in order. But the point that we're looking at today, as far as the committee is concerned, is it capable of being brought into order? It's not a punishment, it's not a fit and proper test, and it's not a punishment for past transgressions. What the committee will need to consider at this point in time is against the long-standing trading of these premises going back to 2003, is it possible with the right management structure for these premises to trade compliantly? And the answer is yes, of course it is, because we're going back to 2019 to look for this pattern that the police refer to. Half of that time the premises have been closed due to COVID, and since they've been open, Mr. Yildiz has been fighting fires, on, metaphorically speaking, on several fronts, and most critically his divorce, which runs the risk of losing the Dolphin completely. And his case before the committee is that he accepts the transgressions that are set out in his witness statement, that these things, the display of the licence, and a number of these other points, and the official transferal of the DPS from him to Yasmineen are in a different category from the management failures that have allowed assaults to take place. Those are where the risk to the public lie. And Mr. Yildiz's case is very clear that these are very serious. Obviously, they're serious. They've been very few and far between, and they are capable of being brought back into the compliant trading that he has demonstrated from 2003 to 2019. That's a very long time.
But my worry remains that he has a history of making promises to rectify the faults at the premises, so then aren't followed through on.
The way to deal with that then would be to suspend the license until these things are in place. That is an alternative and an option that the committee have available to them. They can give a 3-month suspension for these steps to be implemented with the risk of the loss of the license at the end of it. All I'm attempting to do today is to dissuade the committee from the ultimate step, the draconian step, which is final revocation as of now, with no opportunity to come back on it. Even an appeal is not worth doing because we've got the interim step of suspension in the way. So he can't even trade compliantly and demonstrate compliance pending an appeal, because that would be the end of it. He would just be closed.
Councillor Bell, anything else?
I'll leave it that for the moment, thank you.
Okay, sorry, you've had to wait a bit there, Councillor Smith, but here's your chance to start.
Yeah, thank you, Chair. There's a number of points I'd just like to raise. You might need a pen to maybe write some of these down. So my first concern really is about the identification of the suspect. I need to know whether the police have identified this person or not. We've been told that staff have told them who the suspect is. I need clarification from the police as to regards to whether they know who this person is or not. That's the first thing. The second thing is, do we know if the venue is part of the Hackney Knights accreditation scheme? Does it take part in Pub Watch and the Ask Angela kind of scheme for safety for women? I'd like to ask Sarah about how she feels the witness statement from the victim matches the CCTV. I'm sure you have an opinion on that. I'd like to hear how you think it matches the CCTV imagery and the victim's statement, how they match up.
Sorry, which are we talking about? We're talking about the sexual assault, or are we talking about the most recent incident?
Yeah, the most recent one.
Yeah.
And then I also wondered why, and if this is normal, that the incident took place on the 15th of October, but yet the victim's witness statement was provided on the 21st of October. That's a number of days later. I'm just wondering why that witness statement wasn't taken on the night or the day after. Why did it take them so long to get it, or is that normal? So there's a few different questions there.
So we're asking the police that, yes?
Yes, please. There's some to the police, some to Sarah.
So shall I deal with the first and the fourth, which I think relate to the police?
That's a good idea. Please do.
The first about the identification of the GBH suspect. I gave quite a long answer on that earlier, and PC Giles added to it. I don't know if you want me to repeat that, or whether you can remind Mr. Smith in retirement about that. But simply that the pub staff gave a first name and a phone number that didn't work. So police made efforts to try and identify him from the incomplete information.
Sorry, I think we heard that.
Yeah.
What Gilbert is asking, if I've understood correctly, is so basically we understand you did not feel the venue was as helpful as it should have been or could have been. I think the bigger question is, have you, despite that, now managed to identify a suspect?
No, and that's the reason we've asked for the CCTV to be exempt.
Thank you.
And Mr. Smith, in relation to the fourth point, as to any inconsistencies between the complainant's statement and the CCTV, those I'm sure will be explored in any criminal prosecution. But the police would say it's undoubtedly a grievous bodily harm. It's a nasty glassing. You've seen the victim's injuries.
Sorry, that was item 3. Item 4, the gap between the incident happening and getting the witness statement from the victim.
Yes, yeah, no, so I was dealing with 3 as well. Yes, PC Giles can answer it. Certainly not unusual for a victim who's received serious injuries to give their statement a few days later, having given an original complaint to the police that'll be recorded somewhere. So that's not unusual, and certainly given how stretched response teams and detective teams are at the moment. So a gap of 6 days is by no means unusual in respect of that, particularly in light of his injuries. So I would say there's nothing odd or inconsistent or suspicious about that. That's probably par for the course, but I'm sure PC Giles will correct me if I'm wrong.
Okay, shall I move on and just all your questions, Gilbert? So yes. So the licensee, has the licensee taken up the various schemes? Is the licensee a member of Central Hackney Pub Watch, and have they taken on the various new initiatives that have been introduced to safeguard women and spread good practice?
I can answer yes in relation to Pub Watch. Mr. Yield is a member and attends. Ask Angela specifically has not yet been implemented, but easily can be. That would be incorporated into the staff training. The Hackney Night accreditation, I haven't had a direct answer on that, so I don't know if that's a separate thing. I'm not aware of it personally, I have to say. So I don't know what that is.
Hackney Night's accreditation is a fairly new scheme, so it's a question of going through various training schemes. I'm not sure it's fully up and running yet. Councillor Smith, do you want to come back on this?
Can I answer the other question?
Oh yes, please do.
Thank you. In relation to my opinion on whether the victim's statement matches the CCTV, I'm not sure my opinion is worth anything in this regard. I've only seen the CCTV once. It strikes me that we're not in any kind of dispute as to actually what has happened here or what happened to the victim. I don't think there are any discrepancies that I have spotted as to what occurred, and clearly he was the victim of a very nasty attack. I couldn't go behind that at all. What I'm interested in is the timings, and the timings are very clear and they contradict the police statements, even if one takes the statements as being rather loose. Now, PC Flaherty doesn't actually give a time at all in his statement, which is astonishing. PC Skinner's times are all wrong, and PC Sean Evans, I've got the name of Sean Locke coming up, which is throwing me somewhat, wasn't there. But the incident on the CCTV very clearly that the blow was struck at 01:54:38. If the police are saying that the call came through to their radio from LAS at 02:04, that's a total of 9.5 minutes from the blow landing to the police radio being triggered by LAS. So LAS had obviously had their call by then. We are adamant that a member of the staff called the police, and if the police statements are the ones that were saying that the incident happened 20 minutes before LAS called them, that is inaccurate, which begs the question as to how much else is inaccurate.
Thank you. I see Sian has a hand raised. I think that was because her PC wasn't working, which is why she's having to use something with another name on it. Do you want to come in now? And you wanted to speak earlier, and now there's some statements for you to rebut. Please come in.
Yeah, just explain my name. Sean Locke is my married name, and this is on my mobile because I can't use my work laptop. So that's that.
It's fine. I just don't want to offend you by getting your name wrong.
No.
Can I also add, please, that the police have not gone back to the premises to indicate to the staff that the name and the number didn't correlate with anybody. So and this is probably again police resources, but nobody has come back to the staff to say, you know, that number you gave us, it's not working. Can we check we got all the numbers correct or anything of that sort? So in terms of the premises not providing the information, we do refute that.
Thanks, Sian. You've got a bundle to answer there. Do you want to come back a bit?
Yeah, it's going to come down to police resources in relation to going back to the venue, and also there was some slight confusion because they knew the venue was closed. They didn't realise in relation to the CCTV, for example, they didn't realise they can attend and download. So I provided Mr. Uaz's number to the officer investigating the case and explained he actually lives on the premises, so he could download where possible. So it's going to come down to resources. They don't just investigate one crime at a time, I'm afraid. If I can come back on some of the other points, if that's okay.
Please
Chair.
do, yes, please, very helpful.
In relation to the pub watch, Mr. Yildiz, I chair the pub watch he's a member of, and he's come once, and that was on the 28th of July. And we hold monthly meetings, and during them pub watch meetings, we did do a super pub watch, which everyone on the bar was invited to for an Ask Angela and a wave training. He did not attend. He attended the one on the 28th of July. In relation to the witness statement and the delay, what Guy explained is correct. It's not unusual, and due to the level of injuries, we normally leave it a few days anyway before we ask for a witness statement. Sometimes they have to see victim support and stuff like that if they've had that extent of injuries. And the suspect name, yeah, it was just the name and the number. However, if he had used the ID scanner as the conditions state, then we wouldn't be in this position. We wouldn't have to question or have one name. We'd have his full name, address, and details from an ID.
Can I just comment on that, please?
Sorry, so you're
You've been muted. You need to switch.
I double-clicked it by mistake. I'm not aware anywhere in the evidence, but I'm sure the officer will take me to it, of where it's been suggested that the ID scanner wasn't used that night. But in any event, the allegation from the police has been very clear that it is as a result of the non-cooperation of the premises that they don't have the details of the suspect. And if you read PC Skinner's statement, you will say that he says, if staff had only reported it to us, if we'd only had CCTV, if they'd only kept witnesses there, we would have had the suspect by now. None of that is correct. The police were on the scene in under 10 minutes as far as witnesses were concerned. They had CCTV immediately on someone's mobile phone, and the only reason they haven't got a copy of it is because they haven't had the time and the resources to go back and get it, as you've just heard. And they were given the details of the suspect, which we didn't know until today didn't work. And had they gone back to clarify that, the staff would potentially have been able to clarify that yet further. So that puts into question the way it is framed in this summary review application, which is the most serious part of this, is that the premises have deprived the police of the ability to locate the suspect. That isn't correct. This is more down to police resourcing than anything else.
We hear what you're saying. Thank you very much. Councillor Smith?
Forgive me. May I just make one point in relation to Miss Clover about the ID scanner not working? There's a huge amount of uncertainty about when the scanners have been working, because Mr. Yildiz instructed 2 different companies who he appeared to be paying at the same time, and you've seen the evidence about one of them not being in use for a long period of time, and there being uncertainty about the other one. The question must arise that if the ID scanner was working on the night, where is the printout of the gentleman that the staff were able to identify? And the absence of that suggests to me that, and should suggest to you, that the scanner was not in operation on that night.
No, that's not fair. That's for the police to prove. And it's for the police to check the ID scanner, not to fail to check it and then assume that it's not working. We say it was working.
Okay, I mean, this is going round in circles a bit, but it's essential we hear all sides. Go on, Sean.
Sorry, Chair. I did submit further evidence from an email from the ID scanning company who said it hadn't been online since the 8th of October. So that would mean that it wasn't online on the night of the incident.
I'm taking instructions, but that contradicts my instructions.
I did. It was further evidence which I submitted along with a statement, an email chain from the ID scanning company Q Tracker.
I'm not disputing that the evidence is in. I'm saying that forgive me, that isn't the company that he's using. That the emails are coming from a different company that do not license his current machine.
His machine is Q Tracker. When we went, I think it was July. I looked at my statement. There's a question of 2 companies, and he has paid two different companies. One old company he used, and a new company. Q Tracker's the new company, and that's who I've been corresponding with, and that's who provided me with the details that it hasn't been online since the 8th of October. Sorry, my apologies.
And so that's bundle E, which is marked police correspondence.
I'm taking instructions. Can I just ask my solicitor to come in direct on this rather than instructing me? And I have to say, I keep being muted by somebody else in the meeting. I don't know who has the power to do that, but somebody keeps switching my microphone off for me.
Hi, thanks, Sarah. Sorry, just to clarify, Mr. Yildiz has explained to me that there are 2 companies providing ID scan. Unfortunately, he doesn't know which one was in operation on the night, although we think it was not the one that Sean has submitted emails from. Mr. Yildiz has not been asked for any information from the ID scanner that night, but when requested, he can search the ID scan records to see if there's any more information to assist.
Bearing in mind that Mr. Yildiz doesn't necessarily know who he's looking for either, he'd have to do this in concert with the police.
Okay, sorry, I was with you, wasn't I, Councillor Smith? Anything you want to say in addition to what's gone on so far?
No, I just wanted one more point, just about condition 32, which relates to playing music through a sound limiting device. If you know, the local authority has a view on that, George, and you know, obviously, if there's a sound limiting device installed within the premises and set at a level determined by and to the satisfaction of an authorised officer from the Noise Pollution Service, is that noise limiter device working, George, to your satisfaction? Would be the question, I suppose. It also says in condition 32 that you know, there should be no more than background music after 23:30 hours. George, do you have an opinion or on this.
Thank you. What happened is I took over the case in May this year. The previous case officer who was dealing with it, I have no records. One, because he's left the council, and two, because of the cyber attack. As you know, we cannot go back to the records. I've not been able to check. The premises has been shut for quite some time. What happened is on the night when I got Mr. Yildiz, we discussed various ways of reducing the noise. The level of noise that I witnessed in the street is nowhere near background. In fact, it dominated the atmosphere at the back of the premises. It was
George,
the dominant source.
in your opinion, if this sound limiting device was in operation as per condition 32, do you think that it would not cause problems for the residents?
Correct.
Okay.
Chairman, may I come back on that? My instructions are very clear that all the music does go through the sound limiter. Nobody has come in to check that, refute that, obtain evidence to the contrary. Environmental health officers have not come out either to check the machine or to obtain evidence that it's not going through the machine.
Can I just answer, please?
Please do, yes.
As a responsible licensee, we've spoken to these guys several times. It's his responsibility to turn down the music, be a responsible licensee. You cannot just play it. There's a lot of noise outbreak from the building. So even if the sound limiter was in place, obviously there's cracks and gaps allowing the noise to escape. The premises cannot contain any noise. Therefore, it's up to the licensee to have corrected this a long time ago. He keeps saying he's going to do the works in November, December time. But in the meantime, he could have reduced the volume and voluntarily reduce the hours that he operates the pub. If you open till 4 a.m. and we're getting complaints at 2 a.m., a responsible licensee would have said, okay, while these issues are being addressed, I'm temporarily reducing my hours of operation to 1 a.m. or 2 a.m. until the issues have been addressed. It's operating fully and is coming to the committee to say that he's got family issues. Well, that's fine, but you're operating as a business. To turn the music down, you do not need anything. Just lower the volume and control the people at the back. The temporary structure shouldn't be used after midnight because the background level drops and the noise becomes dominant. This is pure.
Okay. Well, it sounds like you're giving free advice there.
On that,
on the premises. Go on, Sarah.
And forgive me, but there are some very important points there. Firstly, we've had no complaints from the residents made directly to the premises. We've asked for the complaints that have been received by environmental health to be disclosed so that we can consider them and see the times, the hours, the places, the locations. And you've already indicated you have not provided them to us, so we're operating blind. So to make changes without any access to the complaints to understand what the problem is would not be a sensible thing to do. And thirdly, if the music is conditioned to go through the noise limiter, which has been set by environmental health, and it is going through the noise limiter, then to make changes to that unilaterally would not be sensible either. And that's something that the environmental health should come out and deal with the licensee with and check the limiter and check the levels. If your predecessor has approved this limiter and the levels that it was set at, then that is the level that we're playing to.
I would make the point we don't employ officers to run commercial premises. We expect commercial premises run their premises responsibly. I can see you there, Gilbert. Mr. Davis wants to come in and make some comments. Can I just let him back in and then I'll bring you back in? So, Mr. Davis, please tell us what you think.
Well, there's two quick points. The first is that, as George said, I wasn't aware of this, but the sound was supposed to be only background noise after 11:30. That certainly has not been happening. It's extremely loud, if not louder, until 4 a.m. I would say the sound normally just keeps going up until it's off. And secondly, I'm not entirely sure what Sarah means by complaining to the premises. Like, how does one do that? You walk into a busy pub at midnight and make complaint. Like like no sane person's going to do that. People in this building have children. That's just obviously not going to receive an effect. I think that's a ridiculous comment, to be honest.
It can be done in writing at any time.
Okay, well, I wasn't aware of that, but that's not clear to me.
No, thank you. We're hearing these views. It's good to get views and counter views. George, I can see you've got your hand up, but I'm going to let Councillor Smith back in here. I feel we're getting a bit lost in claim and counterclaim, and it's going to be for us on this committee to sift out what we can believe and what we can't believe in making our decision. I'm mindful of the fact that we need to take each of these applications separately, and we're still on the first one, although I do expect the second and third to be quite quick. Anyway, Councillor Smith, please come back onto this.
Yeah, Chair, I don't want to labour the noise issue, but I mean, I think it is an important consideration. And I just wanted to ask Mr. Yildiz, essentially, why are you not having the background music, sort of after 11:30?
Can I just check his license, because that's not what I'm reading. I'm looking at page 10 of 34 of the first license, so presumably they're all going to be the same, but I've got recorded music standard hours till 1, Thursday 1:30, Friday 3:30, Saturday 3:30 and Sunday 1. That's the regulated entertainment licensable activity of recorded music.
Right.
I think I can help with this. This is the 2019 new premises license application. Prior to the new license application, there was more of a restriction on music. However, in 2019, the licensing committee granted the application, allowing recorded music, which is obviously above background, until the hours that Sarah has just mentioned. So that's 1 a.m. Sunday, Monday, Tuesday, Wednesday, 1:30 a.m. Friday, and 3:30 a.m. 1:30 a.m. Thursday and 3:30 a.m. Friday and Saturday. So that is permitted. The music does go through a sound limiter, and Mr. Yildiz has also told me he goes around and takes noise recordings, but obviously the extent perhaps of the concern of the residents has not been brought to his attention. As we've said. Yeah, and Mr. Yildiz has just said he's very happy to investigate that further, including getting a sound engineer out to help resolve any concerns that are being made aware to us now about noise. Thank you.
Chair, I think it's important to clarify what exactly these conditions are for each one. Actually, I really do. Page 37 of my document here, there is a noise limiter of 35 condition in there. Page 69, number 32, refers maybe to a different application. The second one, that talks about noise limiting. It talks about background music after 23:30. So, I mean, it is rather confusing that there's 3 different licenses with 3 different, slightly different conditions in regards to noise. So I don't know. I just need clarification on because they can say, well, we're not adhering to that license because that was adopted in 2019, and this new license, no one knows which license we're talking about. It's confusing for them, and it's confusing for us.
We would normally revoke a previous license when we grant a new one. I don't know what happened there. I guess I'm wanting to bring this to a conclusion, but I will be guided by other members, this discussion phase. Do you want me to ask George to come back in and give us some advice on his interpretation? I mean, we're talking license conditions here, we're not really talking general news. Should we bring George back in? No. Okay, I'm being told not to bring George back in. Amanda has her hand up. Amanda.
Yeah, I just wanted to clarify, when you said you're bringing this to a conclusion, are you talking about the first license? Because you said that obviously there's 3 separate decisions, or are you dividing it up into...
My intention, Amanda, was to do concluding remarks from each of the parties on this first license, which is the 2019 license. And then what I'm going to do is go on the other 2 licenses, ask whether there are any particular circumstances that mean we should treat them differently to this first license. Is
Okay.
that an appropriate way to go
Yes,
through
no,
this?
that's fine. As long as everything's getting covered, that's fine. Thank you.
Chair,
And then obviously we will have to retire and consider all of our decisions together. Sorry,
Okay,
Guy, you've got your
just
hand
making
up.
sure. Yeah, that's fine.
I did, thank you, sir. I'm for my part, the decision should be the same in respect of all three licenses, although Mr. Smith's absolutely correct that the third license, the 2019, has slightly different conditions attached to it. And there is a real desire on all parties, I should think, for consistency and that. But I was hoping you hadn't forgotten that you need to watch the video in an exempted session before we go to closing comments.
I think the decision
Only way we can do it. This is just going to get too clumsy. It's just going to be counsel for either side, which then make comments on that if they feel it's needed. Okay, Councillor Smith.
Yeah, thank you, Chair. Just on that question of, sorry to labour this point about the noise limiting condition 32. Whatever application it applies to, I still want the question answered. Why was the music still going on at a loud level after 23:30? There's a condition here, it's right here, and it applies to the two last applications in this pack. Yeah, it's there in black and white. I just want to know why it wasn't complied with.
I can't read that condition. I'm sorry, I can't read what you're holding up to the screen. I don't know what you're referring to.
You want to reference the clause and the page number?
Page number 69 in my report.
I don't have a composite paginated report. I've got.
What's the condition number? What's the condition number?
The condition number is 32, and I think it applies to this. If these applications are 1, 2, 3 in the pack, yeah, number 2 and number 3 have got a condition 32. Page 101 in my pack and page 69. Both of them are the same, exactly the same. And they mention background music after 23:30 hours.
Shall I just read it out? If that allows us all to know what we're talking about.
Okay.
Sorry, I can clarify this. That condition relates to the premises licenses. Of the 3 licenses, the 2 that were in place before the new license was granted in 2019, that condition was on them. Part of the 2019 application was to not have that condition, and that is why the condition does not appear on the new license that was granted in 2019.
Okay, and that 2019 is the first one in the pack, yes?
Yes.
Okay, so that's the kind of existing.
Yeah.
All these licenses are in existence, aren't they?
They are, but the most lenient one is the one that will trump the most restrictive ones. Mr. Yildiz, unsurprisingly, is operating the license that was granted to him in preference for the one that was granted previously to him and his wife. And although it's being suggested that you'd automatically revoke one license before granting another, that isn't actually correct. And the case law of Extreme Oyster, that your legal advisor will be well aware of, indicates that there is nothing wrong with having multiple licenses in place at the same time, but you are entitled to operate whichever one you want to, and obviously you can operate to the most lenient of the conditions. That's what Mr. Yildiz is doing. Now, in terms of taking the other one away, I keep repeating this, and I'm not sure I've heard a satisfactory answer. Before revoking Nuvit's license, you'd need to hear from Nuvit.
Yep. Just on that condition, then, on the first application, the 2019 one, a noise limiter will be fitted to the musical amplification system set at a level so as to ensure that no noise nuisance is caused to local residents or businesses. Right? So this noise limiter is obviously not working properly.
Well, that it's been set by the environmental health officers because that's what the condition requires. So Mr. Yildiz, particularly not having been notified personally of any complaints, is entitled to assume that the level that his machine has been set at, if he plays through it, is acceptable. And until this review came in and the representation of Mr. Vokrach in the context of this review, which was a matter of days ago, we didn't know to the contrary. Nobody's directly responded to that.
Okay, thank you. We hear what you're saying. Mr. Walker, you can perhaps help us on this. I see you've got your hand up.
Yeah, I just wanted to make two comments. The first one is that environmental health do not set the limiter, nowhere in the borough. What we do is, when the limiter is being set, we attend. We are not involved in setting the limiter, because setting the limiter is outside the legislation that we enforce. You cannot be involved in setting the limiter and then take action at the same time. So we advise all the premises, get acoustic engineer and set your limit. It's not up to us to monitor your limiter. So we are not involved. Let me clarify that. We did not set it.
In fact, that's
The second
that's in
point,
that condition.
yeah, the second point I wanted to bring is I want to ask Mr. Yildiz, ever since he opened the pub after COVID, has he not been aware that there's been complaints? When is this the first time he's hearing about noise complaints? Can he answer, please?
Well, I'll answer for him. The answer is yes. We've asked you for details of them and you haven't provided them.
Sorry, if you've asked for details, you know there's been complaints, so you can't say both of those.
In the context of this review, because that's when Mr. Vokrach put in his representation within the 28-day consultation period that there had been complaints. And it was at that point that we said, really? Provide them then, please. And he hasn't.
I'm going to provide the details. I've got it here. I've got all the complaint details here. I will provide to you after this meeting. But the point I'm trying to bring is, Mr. Yildiz has been aware of complaints. I've had discussions with him before the incident. He continues to play music till 4 a.m., keeping everybody awake. He's come out and met me doing noise measurements at the back of the premises. That tells you something. He should have taken the responsibility of reducing the noise while operating till he's got plans to do other works to abate the nuisance.
Okay,
This is all in dispute.
Okay, we hear you're disputing it. So while you're there, George, the two other conditions are about keeping the back doors closed. The rear lobby door is to remain closed except for access and egress. I mean, it's in there twice, I think. That's 37 and 38. Is it your experience that that rear door is kept closed or not?
I don't believe so, because the same music that was playing, I could hear it from the back of the premises and at the front. So there's a breakthrough. If the door was open, maybe it would have been reduced to a reasonable level. I don't believe the door was
closed.
What was closed. And secondly, the lightweight structure is the biggest problem at the back. How can you keep people drinking, shouting, screaming at the back of the premises? It's like in an open field till 4 a.m. in the morning. He's been made aware several times.
Okay, thank you. You're straying beyond your area, the areas we want to hear from you about.
Yes, please forgive me. I keep getting a message that I'm being muted by Councillor Bell. I don't know whether that's correct or not.
It's part of the hearing procedure that if you're not actually speaking, you have to be muted, and only the chair is allowed to be not muted. Everyone else is being muted throughout the hearing unless you're actually speaking. So it's not that they're purposely, well, they are purposely trying to stop you from speaking. Or having any noise, but only the chair is allowed to have his unmuted. Everyone
two others have any additional evidence that we need to hear. And then we will go to the exempt item of the meeting, and with council and nobody else, we will have a look at the video. That's the way and then we will retire and make our decisions on all three applications. I hope that's really understood. So, if I go back, we normally do summing up in reverse order. So I'll try and get it right this time. So first of all, it would be for Sarah Clover to reiterate the main points she's made earlier on and the things that we should take into account in making our decision.
Yes, Chair, well, I can keep this very brief. Thank you for giving me a little longer to start with, but it makes this that much briefer. I have said everything that I wished to say. I'd wish to highlight to the committee a couple of things in relation to the 15th of October, and also, as it happens, in relation to the noise issues. There is an element of ambiguity here. And there is also an element of blaming the licensee, blaming Mr. Yildiz, for example, for the failure to identify the suspect for the 15th of October. And then actually when it comes out, it transpires that much more has been done by the premises than you would read in the statements. And it's been an inability of the police, no criticism intended, but an inability of the police to go back because of their resources. Similarly with environmental health, that they haven't picked up anything about waste. They haven't picked up anything about this noise limiter, not because Mr. Yildiz is doing anything in contravention of the condition and the limits that have been set, but because there's been a changeover of guard at the council, records have disappeared, and so on and so forth. So we do need to be quite forensic about this in terms of making blameful allegations against Mr. Yildiz, but actually understanding what has gone on here. I have referred you to the very lengthy history of trading here. Mr. Yildiz is not a Johnny-come-lately to these premises. He's been there for 18 years. These are, I'm going to use the word iconic premises in Hackney. The building is very special. It has been there a very long time. People come there as regulars. There's been no dispute about the nature of the patrons, the clientele, the demographic. These are people who love this premises and go there regularly. In the grand scheme of things, the number of things that have gone wrong that are a contravention of the licensing objectives and a risk to the public are tiny. And you would wish to compare that perhaps with some of the other problem premises, trouble premises that you are aware of. Mr. Yildiz has taken his eye off the ball in recent times for reasons that he has set out very plainly. And he is sorry about it, and he acknowledges it. And he's had problems with his management and his team, including security. Some of those things have been changed, are in place, and some of those things are yet to be finally implemented. But when they are, and you can set time frames, time limits on them as much as you wish to do so, these premises will go back to the compliant trading that they enjoyed prior to the police becoming upset about it. There's no reason to believe not. And my primary message to the committee here today is not to take this licence away once for all and finally, which is really what we're talking about here. A great deal rides on it, not just for Mr. Yildiz, but for a great number of other people who benefit from the Dolphin in terms of their personal employment and support, or because it constitutes premises that they value in their location. And that is something that you can take into consideration as well. Licensing is a 360-degree exercise. Everybody has an interest in it. And unless there's anything I can answer, that's what I'd like to say to you. Thank you.
Any clarification on that from Councillors Smith and Bell? No. Okay, so Mr. Davis, on behalf of the Balham Street residents, the signatories to the letter from other persons, anything that you want to say in summing up?
I have nothing to add in terms of evidence. I just want to say from the perspective of the building, as I said before, we're being reasonable. We're not unreasonable people. We're not seeking to create, a ton of unemployed people. We just want a reduction in noise at night so that residents of the building are able to sleep. Apparently, we didn't notify them properly, but that's the message we're trying to convey. We're notifying him now. We want it to be quiet at night so we can sleep. Even at weekends, there are children living in the building. They're entitled to go to sleep, before 4 in the morning or before 1 during the week. So that's the primary message I want to convey.
Thank you very much. And authorities case, shall I take? I've lost it. My screen gets jumbled up. Go on, I'll take you first, George.
Thank you, Chair. I've already said what I've got to say.
Nothing
Uh,
more to add.
all I'm going to add is, I would recommend that if the license is not going to be taken away, the hours have to be reduced so as to give the residents a respite to sleep.
Thank you. That's a very clear summing up of your position. And where are we left with now? So we're finishing with the police. Do you want to pick up this one, guys?
Yes, I do. Thank you very much, sir.
Yeah, let me double check. I haven't missed anyone, have I, Amanda? I think that's everybody. Amanda's not heard me. I think that's everybody. I think it's over to you to be the final person summing up, Guy.
Thank you very much, sir. Of course, one has sympathy for Mr. Yildiz and what he's been through in the last few years in relation to the divorce. But the fact is, there have been numerous repeated breaches of the conditions on these licenses. And Mr. Yildiz has been given multiple opportunities to get his house in order. So the question this committee must ask itself is, from where will it get its confidence that things will be different in the future? I'm going to ask you to have a look at the first page of PC Giles's standard review statement, which is at your bundle I, and it reports some undertakings that Mr. Yildiz gave to this committee in October 2019, one of which was to remove himself from the first license, another was to remove himself as DPS, and another was to make a unified application for 163 and 165. Those were undertakings that Mr. Yildiz gave to this committee, no doubt in good faith, in October 2019, and nothing has been done. In respect of removing himself as DPS and replacing him with Yasminine, again, those undertakings were given to the police and have been for many months. And once again, nothing has been done. And it relates back to Mr. Bell's question about the failure to get a statement plan in May 2019. So while there may be nuances or doubts about certain parts of the evidence, this committee can be in no doubt that there is a pattern of breaches of the condition of this license, all of which demonstrates the unfitness of Mr. Yildiz to promote the 4 licensing objectives. And that's something that's been shown before the GBH on the 15th of October and since. And the licensing subcommittee will appreciate the fact that a standard review was in the post even before the October the 15th review. Ms. Clover says the risk to the public is minimal. The anonymous victim of that GBH may disagree with that, but also may be frustrated that his day in court has been compromised by the weak management of the Dolphin. Now, given that you've heard evidence about a series of breaches relating to the scanning equipment and the Dolphin, you may find it pretty extraordinary that Mr. Yildiz still does not know which of the providers is the relevant one for these purposes. And if it had been working on the night, as PC Giles made clear, it would have been very easy for the members of staff to identify him on the club scan. So this isn't simply a trivial matter of conditions being missed and licenses not being up in the right place. This is a wholesale snubbing of the licensing system by Mr. Yildiz over very many years. And what his statement suggests is not a firm action plan, not a change of management, not a new regime. It's simply a wing and a prayer that things might be better for him after the conclusive hearing in his divorce. Now, one wishes him the best in that hearing, but you'd be a naive subcommittee to think that the licensing objectives are going to be promoted, given the absence of any apparent recognition on Mr. Yildiz's part of how to run this pub properly. It is a landmark pub. It's a beautiful late Victorian tiled walled pub. In the right hands, it's of course an asset to the community. In the current hands, it's a liability, and the police have spent many months and many resources trying to get Mr. Yildiz to note the seriousness of his situation and the importance of abiding by the conditions of his license. And time again, he's failed to do so. Time and time again, he said that he will improve this and improve that. And we're left here on the final hour with the proposed DPS, Yasmin, not even at the hearing which may result in the final revocation of the 3 licenses. If she can't be here for this, one wonders when she's going to be available for the Dolphin, and you've had no opportunity whatever to probe the competence, capability, or bona fides of the proposed DPS. So there's nothing that the police have against the pub. It's purely against what has repeatedly shown itself to be incapable and inept management. And for that reason, we're asking the committee to take the final step of revoking the license, in the hope that a proper management and an owner who takes things seriously and is able to abide by the conditions can look after the pub in the future. So that's all I would wish to say in closing.
Thank you very much. I see Amanda has a hand up. Amanda?
Yes, through the chair, could I just ask the chair to clarify with Councillor Lindenberg what his view is about the applicant's suggestion of allowing a period of suspension to rectify things. If members are considering other options, what's his view on those other options?
Thank you.
Yeah, well, sir, we've asked for revocation because the police are advisedly of the view that a suspension will not solve the ills that we've been bringing to your attention. Clearly, if it were between doing nothing and suspending the license, we would, of course, prefer a suspension. Our anxiety is that there's no management plan, there's no plan of action to make things better after the suspension. And there may not be the resources or the capital to do so. It would be very much hoping for the best. And the police have rather too much experience of these premises under this management to believe that would be the proper way to proceed.
Thank you very much. And I saw Sarah Clover had her hand up.
Yes, forgive me, Joe. It's just a correction of something I perceive as unfairness on behalf of the police in relation to the DPS. I did explain that she's out of the country. That hasn't been queried or questioned during the course of the hearing as to what, why, or when, and that's a throwaway remark by my learned friend in closing, that if she can't be here now, then when will she be bothered on behalf of the Dolphin? Of course, we must remember that the police have approved Yasmin as DPS. They wanted Mr. Yildiz to transfer DPS to her, so there really is nothing for the committee to scrutinise in that regard. She's been accepted as acceptable.
I really would we're straying a bit here from concluding remarks, but
I think Sian wanted to make a comment.
I can see Sian has her hand up, and then really I think the point about concluding remarks, we asked for clarification, and we're still getting facts and things the legitimacy of what's being said contested. Go on, Sian. Other people have done it. Come in quickly.
Sorry, I won't do it again. I just wanted to clarify, she hasn't been approved. I've met her once during a meeting. We didn't do any of the relevant checks we would do as a DPS because we never received the forms or the application. I'll stop there.
Thanks. That's lovely and succinct. Okay, Councillor Smith. Your mic, you need to unmute yourself.
Yeah, I'm just asking for a comfort break for 2 minutes, please, Chair.
We have gone on for a while, haven't we? Absolutely. Wow. Well spotted. Okay, I think we all deserve a comfort break. So we will reconvene in 5 minutes should be enough. 10 to 5, which is slightly more than 5 minutes. Okay, see you shortly at 10 to 5, and thank you, Gilbert. I'm breaking our own good practice on remote working and how long we should spend on a screen. So thank you, Councillor Smith, for reminding me. See you.
Is he there?
I am, thank
You are there. Good, making sure we haven't lost you. Thank you.
Are we ready to reconvene then? We have our legal advisor, we have the three councillors, we have counsel and solicitors for both sides. I think we are ready to reconvene. Yes? Lovely.
Yes, Chair. Yes, Chair. That's fine. Thank you.
Okay, so the way I set out my plans for conducting this meeting earlier on, we've heard all the evidence on basically the 2019 licence. Because there are 3 licenses covering these premises. What we also have before us is the previous licence, which for some reason was not withdrawn when the new licence was approved. So what I'm going to do, and I hope this is correct, and Amanda will tell me if I'm wrong, I'm going to first ask the police council to say, are there any considerations that they think are relevant to the previous license that have not been raised already? And then I'm going to say to Sarah Clover, does she have anything? Otherwise, we will just, I think, accept that that we've had all the evidence we need to decide this one too. So, Mr. Ladenburg, can you start with this one, please?
Yes, everything I've said is applicable to all 3 licenses, all of which we invite you to revoke.
Thank you. And Sarah Clover, have you got any, is there any reason we should treat this one differently?
The only reason, and I do keep saying this, is because there is a joint licensee and nobody has used her name once. I'm not representing her, I don't act for her, but from a human rights point of view, she's not before you, and nobody has said anything about her, and I think there are issues there.
Chair, can I just ask, through the chair, if the licensing officer could confirm whether or not the other joint license holder was contacted in preparation for this hearing?
Are we talking to Subra? Yes.
Yes, yes, we are.
Yes, Chair. According to the premises license, is the premises address was in the licensee name, so we did contact it. We sent out the notification of hearing letter. I can confirm that.
And the only address you have is the Dolphin. Is the Dolphin.
Yes, the premises, yes, that's what we got in the license document.
Did you make any further inquiries about the joint license holder, given the fact that it was only the premises address?
No.
No.
We didn't do any further inquiries.
You've heard no representations from the police as to what is wrong with Mrs. Yildiz?
Well, sir, this committee has no evidence that she's ever run this pub or any other, so I'd be very cautious about allowing her to operate the first licence.
Chair, if I can also say that I think the understanding is that in respect of the 2019 licence, that the joint licence holder, I think that she'd left the premises and therefore wasn't actually involved in the day-to-day. I appreciate her name is still on there, but I'm not certain, and I don't know if Ms. Clover can confirm whether or not she was involved since 2019 or the last time this matter came to the committee.
I have no instructions whatsoever. All I'm doing here is a sort of a friend to the court, as it were. Is
no, I do understand that, but I'm saying that your client will know whether or not she was involved in the operation of the premises and would have been able to receive that letter, for example.
He may or may not. I don't know. Those are not my instructions. I don't have any instructions.
And you can't ask him.
All I'm pointing out is that there are human rights obligations on taking away someone's license without hearing from them. That's all I'm saying.
Yeah, no, we've heard you. Thank you very much. Mr. Ladenburg, in your summing up,
yes,
you referred to, as I say, I'm surprised, an expectation on a new licensee. As far as we understand it, we issued the new license in 2019, and our normal expectation would be that the old license is surrendered, and that's normally part of the agreement. Now, I don't quite know why that hasn't happened, but who would be responsible for that?
Not the police, sir. It would be the licensing. It would be the licensing authority. As Ms. Clover says, there's nothing wrong in law with multiple licenses. But in these circumstances where the subcommittee have identified a problem with too many licenses, too many conditions, too many cooks, the licensing authority ought to have either invited that license to be surrendered or revoked it of its own motion.
I think we will have to take it away and do it better in future. Thank you. Can we therefore, we've heard, do my fellow councillors want to hear any more? We've heard the point that's been made by Sarah Clover that perhaps it's unsafe, wrong for us to be taking away a licence from someone who's not there. And we've heard the reason why it is fair from Mr. Ladenburg. Do we have any more questions on this one? No? Okay. So we'll take those comments into consideration and move on, if that's okay, to the third licence. This is the licence which covers the Dolphin Wine Bar and Restaurant, which is 163 Mare Street, and my understanding is it's directly entered from the same premises. It's not really run as a separate entity. Are there any special considerations we should have with regard to this? Again, I think you've already told us no, Mr. Ladenburg, but do you want to confirm that?
Confirmed.
Thank you. And Sarah Clover?
Yes, confirmed also. Thank you, Chair.
Okay, thank you very much. So in that case, we are, I'm afraid, going to exclude public and press. We only do it when it's absolutely necessary. But what we're going to see the video that explains the most recent interview, and that is just for the councillors who haven't seen it before, which is Councillor Bell. We've got two hands raised here. Firstly, I'm going to go to Amanda, because that's the one that's still up. Amanda?
Okay. Yes, just a quick question. I appreciate that we've gone through everything today, but following on the point about the second licence holder, and so that there isn't any sort of dispute about this, are the parties minded that we should investigate or check, adjourn our decision until we've clarified whether or not the joint licence holder is actually still involved in this premises, or proposing to challenge the decision from the committee? Because it is, I suppose, I don't want at the end of the day, after we've issued a decision, for the joint licence holder to come back. So I don't know whether or not the parties are saying they want us to proceed with making our decision today or adjourning whilst we investigate that.
Sarah, can you tell us on behalf of your clients?
I don't have any view or instructions on behalf of my client in relation to this. I'm raising a general human rights point which seemed obvious to me. It's entirely the committee's call as to what to do about it.
Okay, thank you. Mr. Ladenburg, you had your hand up earlier. Are you taking it down?
Yes, I was just simply saying that Ms. Nouth had a hand up. So I don't adopt any firm position on this, except to say that Mr. Yildes's statement is very clear that he has been the sole proprietor and manager of the Dolphin for that entire period. And there is no evidence that she's had any involvement whatsoever in that. So I'd be very reluctant for this committee, which has a statutory responsibility to promote the licensing objectives, leaves things hanging, to hear about a co-license holder of an old license with absolutely no evidence that she's taken any interest or responsibility in the management of those premises. But as Ms. Clover says, there is a possibility that she may emerge from what sound to be quite acrimonious divorce proceedings and claim some vestigial right to the license. But as far as the police are concerned, given that there's no evidence that she has played any part in the previous operation of the premises and has no intention to promote to continue the license, it would not be a bar to you revoking the license in my submission if you felt that the evidence was sufficient to allow you to do so.
Thank you. We've heard the points being made, and we'll make sure in any decision we reference these points in justifying our decision. Sarah Clover, do you want to come back?
only again for points of legal accuracy, a premises license is property under European law, tre tractore. It's a capital asset. You're taking somebody's property away from them. There's no obligation on them to operate it personally or at all, and that's the Hall and Woodhouse case. So you don't equate somebody owning a license with somebody operating a license. If you're taking away their capital asset, you're depriving them of property. It has human rights implications.
Okay, thank you. We've heard what you say, and I have my own view on that, but we are, I think, about ready to go to private session. So first of all, we're coming off live, and we're asking everybody other than councillors, advisors and council for each side to leave the meeting, and then we will have a look at the video evidence, which is going to be shown to us by who's showing us? Is that you, Guy?
It's me.
Easy, Giles.
Okay, you're going to struggle, are you, on your phone? But good luck to you.
I'm going to try my best.
So we got George.
Before you start,